issued by the ONGCL, Your Lordship, in July 2023, Your Lordship, for Your Lordship, by the Chief General Manager, Your Lordship, in relating to hiring of Your Lordship services of 370 number 2 numbers of light vehicle, Your Lordship. Pursuant to that, we participated in the selection process. The tender process, Your Lordship. We submitted our bid, Your Lordship. While that process was going on, if Your Lordship comes to page 125, Your Lordship, there was a minutes of meeting, Your Lordship, at the Your Lordship, instance of the Deputy Commissioner, Your Lordship, Tipsagar, Your Lordship. That is at page 125. Now, Your Lordship, minutes of the tripartite meeting held on 8/8/2023 at 4 p.m. in the Tukafa Conference Hall office of the District Commissioner, Your Lordship. Now, Your Lordship will find, Your Lordship, the meeting was chaired by so-and-so, the first paragraph, Your Lordship. Then he was assisted by ACS District Development Commissioner Tipsagar. The chairman welcome all the members and inform the House that the tripartite meeting is in convened between district and ONGC and various organizations of Tipsagar in order to discuss the issues related to recent tender floated by the ONGCL for the vehicle, Your Lordship. The representative from various organizations is informed that they will declare ONGC bond activities if the conditions of tenders for LMBs are not relaxed. The primary issues raised by the organizations are this, Your Lordship. Now, Your Lordship, thereafter, Your Lordship, after this meeting, Your Lordship, minutes, Your Lordship, which, Your Lordship, on the basis of the threat, Your Lordship, raised by certain organizations, a large number of organizations, Your Lordship, will find there in their affidavit virtual threat, Your Lordship.
You are aware, maybe a democratic movement.
Lordship, unconstitutional. Your Lordship, when
after a democratic movement, including Assam Accord.
Lordship, when Your Lordship, this honorable court after Assam Accord, Your Lordship, has held that Your Lordship, Band itself is an unconstitutional, Your Lordship. Now, Your Lordship, after this, Your Lordship will get it page 127. We received an email, Your Lordship, which says tender has been cancelled, Your Lordship. Tender has been cancelled, Your Lordship. They have, Your Lordship, now capitulating to the demand, Your Lordship, of these organizations, Your Lordship, cancel the tender and take a policy decision to go by the demands made by these organizations, Your Lordship. Now, at that point of time, we came before this honorable court, Your Lordship, challenging that decision, Your Lordship. And if Your Lordship, their affidavit, Your Lordship, page 188, Your Lordship, will get, Your Lordship. This is their affidavit by the ONGCL, Your Lordship. Page 176, Your Lordship. These are the organizations, Your Lordship. They have, by a tabular form, Your Lordship, they have mentioned the organizations, Your Lordship, and their demands, Your Lordship.
Page number?
Page 176, Your Lordship. Various organizations, Your Lordship. One community, 3-4 organizations, Your Lordship, demanding, some are demanding that their people should be given, Your Lordship. And they have also annexed, Your Lordship, the representation, Your Lordship. And these representations are from, Your Lordship, page 190.
So, what is the...
No, my point is, Your Lordship.
What is the grievance?
My grievance is this, Your Lordship. Yes, they are well within their right to, Your Lordship, even cancel a tender process. No doubt about that, Your Lordship. Now, when, Your Lordship, that's a policy decision they have taken, Your Lordship, based on their own assessment of the things, Your Lordship, their own requirements, etc. But, Your Lordship, here is a case, Your Lordship, where, Your Lordship, they have, Your Lordship, go to the tender committee minutes.
How are you prejudiced?
Because, Your Lordship, ultimately, Your Lordship, this decision itself is arbitrary, Your Lordship. That way we have been prejudiced, Your Lordship.
No. Are you admitting that because of the decision taken to distribute by lottery system,
Lordship,
you are excluded from participating?
no, Your Lordship will kindly see. Ultimately, Your Lordship, earlier tender processes laid down certain terms and conditions, Your Lordship. Experience is one of the one of that condition, Your Lordship. And apart from that, Your Lordship, this is a Your Lordship on the basis of the rate quoted by the tenderers, Your Lordship. Now, once it becomes a lottery system, Your Lordship, ultimately, Your
You
Lordship.
are entitled to put it to challenge. Once it is floated, has it been floated?
No, Your Lordship, they have taken a policy. I have challenged, Your Lordship, the cancellation of tender, Your Lordship.
So on what basis?
Basis is this, Your Lordship, they could not have cancelled the tender, Your Lordship, based on these demands, Your Lordship.
Who has the authority of that?
Lordship, ultimately, Your Lordship will.
It is the employer take a call.
Yes,
They
Your
want to go for tender, these conditions, that condition. Now, unless they say that this entire tender is opposed to public policy, illegal, contrary to law, contrary to law, laid down.
My case is that, Your Lordship, that the policy decision, if it is taken on the basis of threat, Your
That's an
Lordship.
apprehension.
No, not apprehension, Your Lordship. Your Lordship will kindly see the minutes of the tender committee, Your Lordship.
If you say that because of this apprehended policy decision, you are to be left out from participation, that's a different issue. But you are allowed to participate.
So, we will be.
Whether see, if even assuming that the earlier tender process follow, is there a guarantee that you will be awarded?
No, Your Lordship, there is no guarantee to that. But,
Absolutely.
Your Lordship, I am challenging the decision to cancel the tender, Your
We
Lordship.
don't find any infirmity. Subject, my brother.
Lordship will kindly see the Annexer D, Your Lordship, the minutes, Your Lordship. Now, minutes of the tender committee will reveal, Your Lordship, that, Your Lordship, now what is the purpose of, Your Lordship, constituting a tender committee? They will require to see whether, Your Lordship, the
But the
terms
tender
and.
has been cancelled. Is the new tender been floated or not?
No, Your Lordship, that will be followed, Your Lordship, since they have come up with that.
As and when it is followed, you may choose to assail it on whatever grounds you think it is.
But, Your Lordship, I am challenging Your Lordship, the decision to Your
Policy decision. You can challenge the policy decision only on the ground that it is opposed to public policy.
Lordship. Apart from that, Your Lordship, if it is arbitrary, Your Lordship,
Where is the arbitrary?
that is arbitrary, Your Lordship.
What arbitrary?
Arbitrary, Your Lordship, based on, Your Lordship, certain demands placed by some organization, Your Lordship, a police. Now, Your Lordship, kindly imagine.
Public sector undertaking, they have taken into account certain demands placed by certain organizations. How do you say this is arbitrary?
This is arbitrary because, Your Lordship, if it is
it is arbitrary if you point out that because of accepting these demands, the level playing field is not given to.
No, Your Lordship will kindly see, Your Lordship, that, Your Lordship, if Your Lordship goes through the representation they have submitted, Your Lordship will find that in every representation there is a threat that we will call for the ONGC bond, we will paralyze the institution.
They have not called for a tender.
No, they have called for the tender. They have called for the tender. We participated, Your Lordship, twice. It was extended, Your Lordship. Then suddenly, Your Lordship, these organizations came up with a demand.
Essentially, what you are saying is that the policy decision like this cannot be taken.
Yes, Your Lordship. Based on this, Your Lordship will kindly see one authority, Your Lordship. That's one paragraph only, Your Lordship. Policy decisions, they are well within their right to change the policy, Your Lordship. Now, Your Lordship, that para 52 of this judgment, Your Lordship. It has upheld the policy decision in this judgment. Para 52, one paragraph only, Your Lordship.
Yes.
May I read, Your Lordship? We have no justifiable reason to take a view different from the High Court insofar as correctness of these reasons is concerned. The courts have repeatedly held that the government policy can be changed with changing circumstances, and only on a ground of change such policy will not be vitiated. The government has the discretion to adopt a different policy or alter, change the policy circulated to serve public interest and make it more effective. Choice in the balancing of the pros and cons relevant to change the policy lies with the authority. But these are important, Your Lordship. Like any discretion exercisable by the government of the public authority, change in policy must be in conformity with the witness-based reasonableness and free from arbitrariness, irrationality, Your Lordship.
What is arbitrary?
Yes, Your Lordship, irrational, Your Lordship. This decision itself is irrational, Your Lordship.
This is a decision taken to withdraw the contract. They have not decided to float the contract as yet. Whether they go by the decision or they don't go by the decision.
They will have to, Your Lordship, because Your Lordship, ultimately, Your Lordship, They will have to go for this, Your Lordship. It is not their
Why do
decision.
you say it is irrational?
It is irrational because, Your Lordship, there will have to be some rational basis for changing the policy, Your Lordship. Now, what is the basis of the change
This
of
is
the
what the
policy?
paragraph 52 says.
Lordship,
Because only because if the policy is changed, it shall not be ground for change.
no ground. But, Your Lordship, if it is irrational, Your Lordship, that will, Your
Say
Lordship.
irrationality about.
Irrationality is this, Your Lordship. What is the rational? They are affidavit as well as the tender committee is minute.
Forget about what demands they have accepted. You tell us as an intending tenderer, how are you going to be affected by this irrationality leading to arbitrariness?
Lordship, it is Your Lordship will kindly see, Your Lordship, when a decision is arbitrary, Your Lordship, in normal circumstances, Your
What is
Lordship.
arbitrariness in the facts? You explain to us. What
No,
is
Your Lordship, that's what, Your Lordship, I am saying, Your Lordship, submitting, Your
We
Lordship,
don't
that
find it on the first of it, in the face of it, because see, at this stage there is no tender.
no, Your Lordship,
There is no tender.
they
They
have
have taken a decision.
taken a decision, Your Lordship, and they have also, if Your Lordship go through the minute, Your Lordship, they have an act, Your Lordship, that they have gone for, Your Lordship, they will float new tender, Your Lordship.
They will float. They have not floated as on date.
Once it is floated, Your Lordship, my right will automatically will be extinguished, Your
We
Lordship.
can't force them to say that no, the tender conditions in the earlier tender must be followed. Can
No,
you say
no,
that?
that is not my case, Your
What is
Lordship.
your case?
My case is that the earlier tender, Your Lordship, they are well within their right to, Your Lordship, withdraw, cancel their tender, Your Lordship. But that will have to be based on certain rational principle, Your Lordship. What is that rational principle here, Your Lordship? As reflected from their affidavit in opposition.
Therefore, we are saying that according to you, the decision taken by the minutes in the as reflected in the minute is opposed to public policy. To
Yes.
that extent, it is arbitrariness.
Yes, Your
So
Lordship.
tell us how it is opposed to arbitrariness.
It is, Your Lordship, it is irrational, and on it is, since it is irrational, Your Lordship, there is no
Now,
rational.
tomorrow, supposing they don't want to go for a tender, can a report force them to do that?
Had it been a case that, Your Lordship, that we will not go for a total tender,
As
Your
on
Lordship.
date, they have not floated a tender.
Your Lordship, they are,
They
Your
may not
Lordship
float
will,
a tender.
Your Lordship will kindly see their minutes, Your Lordship. It is not that they will not.
This minute is a meeting between stakeholders.
No, not that minutes. Minutes of the tender committee, Your Lordship.
Where is that?
That is at page 269, Your Lordship. 269, Your Lordship.
69.
Annexure D, Your Lordship.
You have 2 or 3 page numbers.
Lordship, that's Your Lordship. It is hurriedly find, Your Lordship.
269.
269, Your Lordship. Your Lordship will kindly see that tender committee, Your Lordship, can tender committee take cognizance of these representations, Your Lordship? Is it what they have said? Following organization has submitted queries, issues on tender conditions, Your Lordship. Now,
269 is what? Annexure D.
D, Your Lordship. This is, Your Lordship, minutes of the tender committee meeting, Your Lordship. Subject. Now, last point, Your Lordship, 3. Following organization has submitted queries, issues, tender conditions, so and so. Now, they have mentioned all these, Your Lordship. Now, tender committee, Your Lordship, taking into account these conditions. Now, ONGCL having taken a policy decision based on that, Your Lordship, tender committee saying that we will not continue with this tender, cannot continue with this tender since ONGC has taken a policy decision. But tender committee itself taking into consideration these, Your Lordship, absolutely extraneous, Your Lordship. They don't even have the, Your Lordship, reason for taking note of, taking cognizance of this.
Therefore, we come back. The conditions in a tender may not be favorable entirely to.
Yes, Your Lordship.
That does not give a right to challenge this
Not at all, Your
unless
Lordship.
it is opposed to public policy.
Lordship, not at all.
Rationality,
No.
rightly pointed out. Now, as on date, they have taken a decision
No.
not to float,
Not to float, Your Lordship, to cancel.
to cancel the tender which was floated. You are not a shortlisted, you are not the L1.
No, Your
your
Lordship, not.
papers were not considered. Now there is a possibility that they may re-float a tender,
Lordship,
reissue a bid.
Lordship.
In what form, in what manner is not available.
No, that is, Your Lordship, it is available, Your Lordship.
That is only a discussion, Mr.
That is
No,
not
no.
discussion.
Subsequent to that, they have taken a decision, Your Lordship.
Where is it?
Yeah, I will show that, Your Lordship. That's page 132, Your Lordship.
Page number
page 132, annexer E, page 132. Etu ne etu. 132.
Upper or lower? Page number. Two
Upper.
page numbers are there.
Extremely sorry, Your Lordship. 132. Top.
One,
Top. 132.
one,
19.9.
Lordship. 99. 132, Your Lordship. Top, Your Lordship.
no,
I am extremely
top,
sorry,
there
Your
are three page numbers in some pages.
Lord. It is in fact, Your Lordship, original writ petition. I am sorry,
Okay.
Your Lordship. for that.
Yes.
EPC meeting so-and-so held on so-and-so reviewed the evaluation of tenders for hiring light vehicles and decided hiring of light passenger vehicle and one applicant, one vehicle basis at the rate offered by ONGC using raw lots. As per decision taken by the EPC, provision of interim have been modified and in respect of the tender for hiring light vehicle Assam as per so-and-so. This was implemented after suitable modification which may be required. System. This is your according.
What is the position now?
Now, Your Lordship, it is they have not issued tender immediately.
What is the position in respect of hiring of vehicles? Are they ready?
No, Your Lordship. They are, Your Lordship, because of this, Your Lordship, election and implementation of the model code of conduct, Your Lordship, they have not done so. Your Lordship, probably in the next week they will issue tender.
We are asking you what is the position at present. Was there any contract, earlier contract
Yes. That they have been continuing
that day?
till July, July 31st, Your Lordship, this conflict will
But
come. This is precisely my case, Your Lordship. Now I leave it to Your Lordship. My humble submission is
No,
this, Your Lordship.
no. We understand your submission, but we don't understand it. It is not your case that you are excluded by the new.
No, Your Lordship. I will not be excluded, Your Lordship.
It is not
That-
the case that you are the L1 contractor
Lordship, no.
or likely to be the L1
Lordship.
contractor. So
Your
how does
Lordship,
it affect you?
Your Lordship,
Whatever conditions.
my effect, Your Lordship, this, once, Your Lordship, a process is initiated, Your Lordship. If that decision, Your Lordship,
That's right. So therefore you support it by your submission. Say that process initiated. You were
I'm
at
writing.
a fairly higher ground than your competitor in order to be considered for the
no, that, Your Lordship, that stage has not reached, Your Lordship.
Yeah.
Number one. Number two, Your Lordship, I am concerned with Your Lordship abandoning this process, Your Lordship, which in my humble submission, Your Lordship, based on there is no rational basis for abandoning this
We
process.
have right to forward. See, we will interfere only when we find that your rights, which are vested for rights which have been accrued by virtue of these, are likely to be
Your
affected.
Lordship, once a decision is irrational, Your Lordship, in my humble submission,
It is an irrational. This is not a public interest litigation.
no, Your Lordship, I am
This is a inter-party litigation.
Lordship.
So you are concerned with your getting the tender or your chances of getting the tender.
Lord.
Unless you show us that because of this decision, you are likely to be excluded or the level playing field which was there earlier is not available to you.
Lordship, if Your Lordship, the decision.
Whether this decision is in the public interest or not will be.
No, I am not on public interest, Your Lordship.
Decided.
Had it been, I am not on public interest.
Let us say, in a hypothetically, let us say, you today complain that this is an irrational decision.
Lordship.
Tomorrow the tender comes, you participate, by lottery, you get it. Will you still say that it is an irrational decision?
No, Your Lordship, if a decision is irrational, Your Lordship, then Your Lordship, it will, even if I get it, then also it will be, Your Lordship, it will remain an irrational decision, Your Lordship.
Then
Whether I am
you are
getting it or
urging, what you are urging is in the nature of public interest.
no, Your Lordship, my individual, Your Lordship will kindly see, Your Lordship, once, Your Lordship, a decision is arbitrary, Your Lordship, the moment it is arbitrary, it is in teeth of Article 14 of the Constitution of India.
We are not convinced.
No, that's for Your Lordships. I cannot, Your Lordship. I can only argue, Your Lordship. I am arguing. Rest upon Your Lordship.
All right, you serve notice on the other side.
Lordship.
Hear them.
Lord.
After you, but we are not passing it.
Lordship. I leave it to Your Lord.
Heard Mr. S. Bota. Anyone for the respondents?
No, Your Lordship, probably Union of India will be
I
represented.
is hearing for reference number 10, Deputy Commissioner.
Rest,
That is DDP
register post.
respondent number 10. Appeal is directed against the judgment. The order dated 18/6/20 for 608 petitioner that have been taking the title of supplying what is it, light motor vehicle
Light, Your Lord, motor, light vehicles, Your Lord. Hiring of services of light vehicle.
in response to a tender, response NIT by the 20 calling for submission of bids for hiring of light vehicle. While tender process is underway, bids have been submitted. There was
কাটি
lot
দিব
of
লাগে
demand,
তোমার
there were demands made by the local organization requiring the ONGC to change the norms of the tender and certain local funds etc. were called for. Funds were called or were likely to be
they are threatening to call bond.
or in the event these conditions are not fulfilled, then the local organization threatened to call for funds in the ONGC operating area. So, in order to ameliorate the situation, a meeting was called for to discuss and there is the minutes of the receipt.
Minus page 90, 125, Your Lord. Can accept PU.
In 51.
By meeting held on 8/8
Lords,
8/8/2020 in the presence of the district resolution was adopted that tender for single vehicle be accepted. The following resolutions were adopted. Page 126. One. First, when there, where is the tender evaluation committee?
Lords, that Your Lordship will get. Page 252, Your Lord. 269, Your Lord.
Annexure D.
Lords,
First, when there, the tender evaluation committee. Taking note of the decision, taking note of the resolutions adopted by what was the decision taken?
Your Lordship will get.
Decision was taken to cancel the tender number 2 for hiring of 370 numbers of 370 numbers of light vehicles in second taxi services for Assam assets for a period of 4 years, as detailed in para 6.2 above. At page 75, the tender committee recommended. Being agreed, the petitioner, the appellant, as a petitioner, report finding so being challenged, the decision taken by tender evaluation committee cancel. Let us see yet what you consider it. I already again it's decision taken by the gender evaluation committee or by the ONGC authority is irrational and therefore calls for interference by this court under Section 2. He has referred to judgment the apex court rendered in so and so, reported in 2010, section 3. So, referring to paragraph 2, he submits that notwithstanding that the government or the authority concerned has the discretion to change the policy or to adopt the policy or change circumstances. However, this discretion should be exercised by the government, the public authority, in conformity with the mandatory reasonableness and free from arbitrariness, irrationality, bias, and malice. Mr. Monaco submits that this decision to cancel the tender was based on the pressure tactics adopted by various local organizations which public entity like agency or not have come to. That apart, tender evaluation committee is not the authority to take a call or change of policy. However, the tender evaluation committee recommended cancellation and persuaded the tender in which the petitioner rather than intimated tender as participant. Yeah, however, submits that as of date, no fresh tender has gone forward by the agency. Submits that in view of the irrational decision to cancel tender, the matter ought to have been given due consideration by the current judge, and that having not been done, present appeal is filed, calling for application with direct. Left notice being issued of the respondent. One, two, three, four, five, six, 7, 8. The report and the expert report in 1 week. To be tested immediately after on 17th.
Sure.
17th July. Since the city board represents this order number 10, notices the way, however, active copy is furnished within a period of 2 working days. Custody is also permitted.
Sure.
to respond.
Custody will be difficult, I will have to go to.
Prayer for
plea or-
interim may be considered.
Sure.
For the next hearing.
I'm extremely sorry for your lordship traveling with this 2 page in which.
Not sorry, we are not sorry.
No, we
We have
are.
to go through papers you point us. We are just asking you for clarification, which page number.
Lord.
That's all. When will the matter?
AB matter, my lord.
Huh?
Anticipatory bail matter.
Huh.
Now, what has happened is that here the petitioner, he's a head teacher of a lower primary school. He's a co-accused in the FIR.
No. What happened to your mention memo? Not
Yes,
rejected.
it was not allowed, or I don't know. I had spoken.
Second bail. Is it a second bail?
No. It is first.
Your filing number was incorrect. You mentioned in the mention memo.
Yes, it was done from the advocate clerk side. That was.
We don't know, but when verified
But
according.
it has not gone. Either in the filing section, they were ready to correct it yesterday itself. But it had not gone from here. So that's why the section said that no, you have to mention it directly before the owner.
See, the verification was done by the court master by sending it to the filing, and filing said that there is a incorrect filing number.
They had got the correct number, but why they have done it, I don't know, Your Lordship. Yesterday I was there.
You bring it up before the registry. What can be done now?
Kindly list it on urgent basis, Lordship, today as an unlisted matter, as the last item also, as the last item.
All right.
May it please, your lordship. I'd like to mention item number 15 of today's
Item number
15.
uh,
I have instruction to withdraw the matter, your lordship.
item 15. At the
15.
request of Mr.
H. Burago.
H. Buragohai, it is submitted that the AB petition is not pressed. The petitioner is not pressing the AB petition any further, and accordingly he seeks liberty to withdraw the same. So, AB petition so and so is therefore dismissed on withdrawal. Interim order, if any, stands vacated. Item number 15.
15, lordship.
Yes.
Obliged, lordship.
Yes.
May it please, your lordship. I am paying for listing of two petitions of motion today. My lord. Yesterday I filed my it has been numbered.
What matter?
for
What
the
matter?
Itanagar bench, my lord.
What matter?
Tender matter, my lord. I was declared L1. After declaration of L1, my
You did not send your mention memos.
it took some time to take permission. It was of Itanagar bench, my lord. So I filed after taking permission to file, my lord. That's a file, my lord. After taking the permission of filing, my
We
lord.
don't know. You'll have to be checked up to the bench. You hand it over subject to clearance from the registry.
Already numbered, my lord.
Is it for? It is for Itanagar bench.
It is pertinent to
Have you taken permission to file it
Yes,
here?
my lord. After taking permission, I have filed, my lord.
Ah.
But by the time I received the permission, I filed, my lord. The time for mentioning was left out, my lord. It was by 12. I have to send the mention. I could not send it, my lord.
We don't know. We'll see
Lordship.
for filing. But you have to inform the government advocate of.
I have informed the office, my lord. I will mention him.
Huh?
I have informed the office.
No, is the government involved here?
Yes, my lord.
So you'll have to serve copies on the government
Copies
advocate.
have served, my lord. Yesterday I have
All
served.
You have to inform them that the matter is permission has been given for taking it unlisted.
I will inform right now. my lord.
Yes.
Oblige, your lord.
Like 1, 2, 3, and 4 are similar matter. Already status quo order has been granted, fixed on 19th.
Page number 69, I have annexed, my lord.
That order has also been annexed in the
Yes.
item number 1.
Page number 69, my lord.
Onto this.
WPC 3354.
My lord.
See page number 69, Mr. Bora.
My lord.
Same.
78. It is
70.
70. Same order I have, no,
Same.
forwarded,
Same.
Lordship.
Same order. Heart so and so. Same order. List on so and so.
19th.
Date is mentioned here.
Along with
So status quo till
Status till the next date fixed.
Fine.
These are all fixed on
19th.
19th, my lord.
19. 19/7.
19th.
Status quo as on date till 19.
19th. Obliged.
Yes. Item 1, 2, 3.
1, 2, 3.
Obliged, my lord. Deeply obliged.
Lordship. This is an application under section 439 KRPC.
We'll call for CD.
See, my lord.
Learned Council for part. The call for CD.
My lord.
This is NDPS.
NDPS C, my lord. 20 C, my lord.
Tell us when you can get it. Kamrup Metro.
My lord. It is July 18th, my lord.
18 July. Please on 18 July. For CD. Council for
May I be people?
call for CD.
My lord,
POXO.
my lord, my lord, just make my lord, my submission, my lord. Section 12, my lord, basically this section is not affected, my lord. Check if you see the FIR, my lord. Kindly see
Therefore,
the
we want
FIR.
to call for
page.
the CD. Let's call
My
for the
lord.
CD.
Today I'm 58 days, my lord.
Huh?
Today I'm behind the bar 58 days, my lord. 60 is the statutory period, my lord. Except section 12, which is punishable up to 3 years.
Without a
3
CD,
years.
what can be done?
All
Let us have
sections
a
are
look at the
available, my lord.
CD. Why have
That-
you filed so late?
My lord, that's what.
Why did you file so late?
My lord, loco, rejected, my lord, on 20, my lord.
Huh?
Very recently rejected, my lord, 24.
Ah.
24/6, my lord.
So have it on 11. You'll
So-
fix it on 11. Next vacation court.
My lord.
Matter will be listed on 11.
11,
Call
ma'am.
for CD as it is submitted by the counsel for the petitioner that he has already been in custody for 58, 58
58,
days.
my lord. 2 days left.
58 days.
My lord, in the meantime, notice will go, my lord. It is the my lord, my lord, 12 is
notice.
here, my lord.
Notice on respondent number 1
Respond number, my lord.
by
2 and 3, my lord.
1, 2, 3.
respondent number 1, 2 and 3
No.
by registered post 80 and also
My lord,
to the concerned police station.
my lord, officer in charge of the concerned place.
The petitioner will file affidavit of service of notice by 11th.
My lord,
You have to take steps to the police station.
My lord. Trustee, my lord, so let
Through the
notice
APP also will,
my lord, my
kindly,
lord, my lord.
kindly,
through
that
the
may be
APP,
permitted.
list on 11,
My lord.
Affidavit is not required, my lord. Then
not required.
applies, my lord.
Yes.
Please, your lordship, it's a charge sheeted case here. POCSO, your
My lord,
lordship.
section 4 is here, my lord. Notice and scan copy, my lord.
Third learned counsel. Issue notice on respondent number 2 by usual course registered post as well as through the concerned police station, Goripur police station. Call for scan copy of the
Along with CD,
case,
my lord.
along with CD, the case record, being special 347 of 2024, pending before POCSO court,
POCSO, Dhubri, your
huh?
special judge, Dhubri.
Special judge at Goripur in the district of Dhubri. Special judge at Goripur,
Dhubri, your lordship. Special judge, Dhubri.
special judge Dhubri. Better be-
Lordship,
matter-
report taking is to throw additional.
No, it will,
No,
Yes,
you better take
that's
it
it.
through the police station.
my lord, as per Deepak Nair case, my lord.
You
they
serve it
will
on the police
my
station.
lord, to the, okay. 23rd, my lord.
23rd of July.
Just may pay for 175 days in custody, your lordship, the student on 16, 15 or 16.
My lord, it's hardship case
15 or
Scan copy will have to,
will come, my lord. In the meantime, notice will also start.
23rd is 23rd. Yes, Mr. Kotoki will call for CD.
My
You know,
lord.
your lordship, I kindly see the scissor list. Only one railing, my lord. That is phase 11, my lord. Iron railing and wine and rod, my lord. I'm a rack picker, my lord. Phase 11.
Page 11.
Only these two were seized, my lord. That way from a unused condition. My lord. I'm a rack picker, my lord. Garbage picker.
Where is the FIR?
That's why your lordship will find at page
Page
Seven.
9, my lord. Page 9.
9. Since I failed to produce documents, how can I produce those documents? My lord? I'm a rack picker. That he was finding an article of garbage carrying rickshaw. He is unable to produce documents support of the suspected stolen. These two articles. Already in custody since 14/6.
Let the CDB call for it. Is from where?
This was Bhangagar.
Also, we'll have it on 11.
11.
11.
11.
Call for CD list
Right.
on 11.
Already seizure has taken place. My statement has been reported. And there is no complaint that it was stolen. It was lying there. When my rack picker, I took it away. That's all. Matter is then.
You have to let us see on 11. But I don't think it can be called for today. Can it be called for today? No.
Today itself, my lord.
No. Can you
CD.
get the CD today?
No, no, no.
Okay.
Today not.
List on 11. call
My
for
lord.
CD. Yes.
Against the order dated 15/5/2024, page 33, ma'am. Whereby my petition under section under order 22 rule.
What is the order? What order was passed?
My lord, I filed an application under order 22 rule 97 and 101, my lord.
Hmm.
And by this order, that petition was rejected without considering my right title interest, my lord. My lord, the operative part will start for What happened in this case, my lord? Initially, the title suit, my husband was a party, and subsequently, prior to execution, my husband died.
He has heard learned counsel of the petitioner issue notice returnable. Where is it coming from? Hailakandi. Returnable 4 weeks. Steps on the respondents by usual course and registered post within 1 week from today. Dusty is also permitted. When is the next date fixed?
6th, my lord.
6th of
6th of this.
matter be listed on 5th of August. 5th of August. Till the next date fixed, the proceedings in Miss case number so and so shall remain state.
No, proceeding in title execution,
Title execution suit. Where is the number?
my lord. The 10 of 2016.
Title execution case number 10 of 2016 will remain state. Yes.
Deeply obliged.
Yes.
Lordship, the opposite party hearing presented a suit. Lordship, the opposite party was the plaintiff, and the present prisoner was the victim.
Where is that order?
Order is at page 64, Lordship. Page 64, Lordship. Para 5, Lordship. That is the relevant portion. The consideration on which the appellate court rejected our prayer. May I read, Lordship? The fifth paragraph, on consideration, it appears that the petitioner appellant has stated in paragraph C of the petition that according to law, the said order of temporary injunction without specific mention itself is valid. This is the observation of the learned appellate court. Purely basing on the statement made by the present petitioner in the before the appellate court, this has been rejected without considering the other aspect.
What is the statement made? What statements were made?
Lordship will find at page 60. Page 60, Lordship. This is the ground taken by the present petitioner as the appellant before the appellate court. One of the grounds. Page 60, paragraph 4. Lordship. And connected appeal is already admitted, Lordship. Who is just it was the prayer of the petitioner to stay the proceeding of the stay of the operation of the impugned order 29-4, Lordship. That is the prayer, Lordship. Pending disposal of the appeal. Appeal is still pending, Lordship.
Before the first appellate court?
Yes, Lord. Only our prayer for stay of operation of the impugned order has been rejected. And that too on the basis
What was
of
the order granted by the trial court?
Trial court, the order is at page 41, Lord. It runs from 41 to 48, Lord. And learned trial court also missed out the fact that we are in possession of the suit landlord, Civil B2 landlord. There is a difference of boundaries between the case projected by the plaintiff and from our side. Complete difference. And we are in this possession of the land since the day of purchase.
What is the appeal number?
Appeal number is 1 of 2024.
Where does one find it?
Lordship, it is page 49. Miss Appeal 1 of 2020. It was last fixed on 25/6.
I heard learned counsel for petitioner. Petitioner is aggrieved by the order dated 10/5/2024 passed in Miss J case number 63 of 2024, whereby the prayer for injunction, praying for whereby the prayer for grant of stay in respect of the order dated 24/4/2024.
29/4.
Huh?
29/4.
29/4. passed in Ms. J case number 61
Yes, Lordship.
of 2023 was rejected. It is submitted that the appeal is still pending. Appeal is pending.
Yes.
And in view of the impugned order, petitioner is likely to face grave hardship and has therefore approached this court praying for stay of the impugned order dated 10/5/2024 passed in his case number 20. Issue notice, returnable 3 weeks. Steps on respondent number on the respondents / opposite party. Steps on the opposite party plaintiff by registered post as well as by usual course within a period of 1 week from today. Matter be listed on 7 on 31st of July. Till the next date fixed, impugned order dated so and so shall remain stay.
Lordship, the parties may be directed to maintain status quo with regard to the B2 land.
We have directed a stay.
So, Lordship, the original order 29-4 is required to be stayed. 29/4/2024. That was the prayer before the learned appellate court.
Parties to maintain status quo with regard to
Schedule B2 land of the plaintiff.
where is the B2 land?
B2 land is at page 18. Lordship. Page 18, schedule B2 land. And it was their prayer at page 30 to seeking injunction with regard to B2 land. Page 30, their prayer.
The petitioners, the parties are directed to maintain status quo in terms of the prayer made in the petition with regard to possession of a schedule B, capital B, within bracket 2 land
Of the
of
plaintiff.
the as mentioned in the plea.
Lordship. And with
Yes.
Yes, may I, my lord,
You are
update-
challenging which order?
my lord, order dated, that is page number 19, my lord. 25/11/2017, my lord.
19.
2019, 2000, page 19. Here, my lord, the petitioner contended the
Passed by which court?
by my lord Lucknow court, family court Lucknow.
Then why are you here?
My lord, because that all the cases are pending still now in that before the court, my lord, that is page number 40.
No,
my
but
lord.
this order you have to challenge before the competent court. Why, how this court will have a jurisdiction?
My lord, on that ground that divorce case is pending before the family court.
You urge that before the High Court
Yes.
of Allahabad.
My lord, may be taken on 11. I'll take the withdrawal. 11th of
Learned counsel for the petitioner submits some instructions are necessary in the matter. He submits that the matter be listed on 11 July. Yes,
Inform order at page 17.
17.
18 is the operating party. The petitioner is directed to pay 3,000 rupees per month to the respondent.
We will issue notice at this stage.
Minor.
Heard learned counsel for the parties issue notice. Mr. Sharma appears on behalf of respondent 1, State of Assam. Steps on respondent number 2 by usual post registered post within a period of 1 week today. Custody is also permitted. Prayer for interim will be considered upon service of notice on respondent.
Fine.
List again on 29 July. Yes.
Case has been charged sheeted.
Charge sheeted.
But I'm moving to appear to face the trial.
And Lordship is aware of the fact our own High Court judgment, Supreme Court judgment, that police cannot declare the absconder. My lord, before my lord submission of colleague, my lord, Lordship may kindly page 2, my lord. Page 2, my lord. Cost title, my lord. Tezpur PS case number 208-19 under section 448, 376, 511, my lord. Yes. Then Lordship may kindly peruse the page 17, my lord. Particular of the FIR, my lord. Received and registered PS case number 208 of 19 under section 448, 370 IPC reduced section 8 of POCSO Act, my lord. That part is not available in the my lord cost title, my lord. Effective, my lord.
You know, highlighted that. You correct it
My lord.
by hand.
I'll correct it.
Correct it. Meanwhile, it is charge sheeted, so you can only call for the
Scan copy and
Scan
notice will
copy.
also go.
as well as the
Notice will go.
scan copy of the case record, and we'll
Right.
have to serve notice.
My lord.
Heard.
And
You make the corrections
my
on
lord.
the signature of the court master.
And also implement the respondent number 2, my lord.
Not impleted.
Not impleted, my lord.
You have to implement.
My lord.
I'll file a.
POCSO is not.
Then we can't.
I'll file.
My
No,
lord.
no, we'll not like
Yes,
to take
my
it.
lord.
You file an I, if you want, we
My
can have it listed on 11.
My lord.
11?
Yes.
It is submitted by the learned counsel to the petitioner that you'd like to file an I for implement of the victim/informant. Therefore, submits that the matter be listed on the next available vacation bench is on 11. Mr. P. Sharma,
My lord.
LRTP, does not declare made, list accordingly on 11th of July.
In this case, CD may be called for.
Learned counsel for the it's called for CD.
14. Item 14.
Steps on
Here is also section 6 of the.
steps on respondent number 2 by a registered post judicial course and also through the concerned police station within a period of 2 weeks. When do you want it? 16.
Yes.
Within a period of 1 week. It's the matter on 16. Steps within 1 week.
Wait, please.
Yes.
Well, this is 439 application. The petitioners are in jail for last 71 days as on today. Well, FIR, your lordship will see at page 13. Page 16 is the FIR. Allegation is very, my lord, narrow, my lord, against the petitioner. He received only a phone call. May I read the FIR?
Yes.
FIR was registered on 18 April and allegation is of 16 April. Kindly note, my lord, date 16 April. This is to inform you that on 16 April 2024, a convoy comprising strength of 1 junior commission officer and 16 others ranked, including 2 Tata 407 and 1 Tata 1212 vehicle of 31 Assam rifles moving from Changlang, it's in Arunachal Pradesh, to Soha, was ambushed by EUZ, that is, my lord, unknown group, my lord, at around 8 hours at general area Namdang, Tinsukia district, Assam. The convoy came under heavy volume of small arms fire accompanied by lethal. During the counter ambush firefight number so Havildar, General Duty 1 Om Prakash Malik, who was in the vehicle, so sustained gunshot one police person was injured. Then it was registered under section 326, 307, 427 IPC, my lord, a red section.
What is the meaning of this term called lathot?
That, my lord,
Accompanied by lathot?
that I was also searching for, my lord. Some, my lord, Anyhow, my lord, PP will say, my lord. Now, on the basis of this, my lord, what happened? These two petitioners, my lord, they are the son of Gaumura, of the village. Then your lordship will kindly see page 18, my lord. On 18, my lord, we are arrested on 22nd of April, my lord. On 24, my lord, we are forwarded. Your lordship will kindly see page 18, second para, my lord. Accused person John Hakun. We are not John Hakun. Mongkul Mosang is the petitioner and Manong Mosong is the petitioner too, my lord. These two are produced after arrest. Then your lordship will see page 19, second para, my lord.
Hmm.
Custody of hour was not sought. Only your lordship will see page 19, second para. The IO has also prayed for the police custody of accused person John Hakun. He is the suspected man, my lord, for 5 days. Then at below your lordship will find page 19. Remand the other co-accused Mongkul Mosang and Manong Masong to judicial custody. No custody was sought for. We are villager, my lord. Then your lordship will see page 20. 4 witnesses have been called for of the village. Their names are, my lord, Shiva Tasa, Marta Sanke, Sumting Sanka, and Srimati Likname Sanke. These 164 statements are recorded. I have annexed those. Those also does not implicate. Then your lordship will kindly see, may I read the other portion, page 22. I'm showing only the relevant portion. Page 22, third paragraph, my lord. It starts from the statement of the witnesses. Under section 164, CR will see also show that they no suspect Mitkun Sanke who belong to NSCN cadre. The IO has also mentioned that the accused person, specifically that accused John Hakun, had been providing food and logistics to the extent. But this is the allegation against that person. Now, the lordship will kindly come to the forwarding report. Because our allegation is only receiving a phone call, my lord, being a villager, confined to that only, my lord. So your lordship will kindly see page 24 is the forwarding report. May I read the second line, my lord? Second. The brief facts of the case is that on 18/4/2024, complainant Uttam Patil, adjutant 31 Assam Rifle Camp Sanglang, lodged a written FIR in Margherita PS on 18/4/24. That on 16 April 2024, that is the date of, my lord, when abuse happened, my lord. A convoy comprising stand of one so and so, so and so. That is the repetition of the FIR. Now your lordship will kindly come to the suspect, the allegation against us, my lord. Page 25. Your
Yes.
lord, page 25. Serial number 6 onwards, I will study, my lord. I'll read, my lord. Another suspicious number 92 so and so has been identified through the TDR, call details report of prime suspect number so and so Lakam Sanke. His number belongs to Sumtik Sanke, one of the 164 statement witnesses, who further identified herself during interrogation as wife of Mitkan Sanke. She to confirm the 2 phone numbers mentioned in point number 1, so and so and so on, both are being used by her husband, Mitkan Sanke, alias Lakam Sanke, who is an active so and so. Now your lordship will come to serial number 7, the allegation of receiving a phone call only. The CTR analysis of number 600 so and so revealed that he contacted phone number 708-534-6143 Mongkul Mosang. This Mongkul is one of the petitioner, madam. It is the son of a Gaumura of the that village, madam. So
Both are brothers.
Yes,
Brothers,
brothers.
Both
they
are
help
brothers.
them, Lord.
Brother. No. Thing is like this, my lord, if I can say in nutshell. Only, my lord, allegation is that we receive a phone call incident happened on 16th of April, my lord.
Hmm.
Some abuse took place between some organization and so and so. On 18, my lord, some unknown person called these villagers who are residing in Sanglang district. These two brothers, my lord, one of them received the phone call. That is the only allegation. So the allegation reflect paragraph 7, your lordship will see page 25. The CDR analysis of number so and so revealed that he contacted phone number 708 Mongkul Masang. I did not call, my lord. Petitioner. Somebody called in this phone number, who is a son of Gaura of Renew village under Manmao PS Sanglang district on 18/4. Kindly note the date, my lord, because they are linking it to the incident offense.
Hmm.
So date of incident is on 16 April. And after 2 days, this phone call was received by one of the petitioners on 18/4 as per page 25 serial number 7. Kindly note, my lord. So 18/4 is the evening time. 3 calls were received by the petitioner, one of the petitioner, and who further on interrogation of Mongkul Mosang, that is the police person, my lord. He admitted that he sent his brother Manong Mosang to help the insurgent group which was hiding in the village. That is subsequently.
What is the stage of investigation now?
Investigation is going on, Lordship. They have helped the extremist, Lordship, by showing the road to go out from the village. And moreover, Lordship, from the CDR also, their involvement is there, Lordship.
That's why I'm
According to
referring-
CDR,
Their involvement is to the extent of phone calls.
Yes,
phone call.
receiving
After
a phone.
receiving phone call, they have helped them to go out from the village, Lordship. He have sent his uncle and younger brother.
My lord, allegation has to be linked to the incident, day of the incident. Then only this prima facie case will come. It is a case they are saying.
It is not just the incident, it's a conspiracy leading to and after the incident.
Lord,
So it's
Not-
not just required to be linked to the incident. There's a section of the UAPA also.
Lordship, then
Again, this-
Havildar also, one of the Havildar also was injured, Lordship.
So for UPPFs, my lord, I have a submission that I will submit, my lord.
Ah.
How the ingredients are not affected to be. I have relied on some judgment, my lord. Because on exact like circumstances, court has granted bail.
You tell us.
Yes. Now your lordship will see one more thing, my lord. At serial number 7, it says that one of the phone number from 600 phone was received by this one of the Mongkul Mosang petitioner.
Hmm.
So accused petitioner, the phone received by him is on 18/4. So the incident is of 16 April. So they have to link the, my lord, my link to the association on 16/4 to show a prima facie. Now on this, my lord, your lordship will kindly see, because I have to be a part of that abuse or I have to be a part of that illegal activity. So far, my lord, then only this section 10 or 13 is affected. One judgment, your lordship will kindly see. I will provide two judgment, my lord, then I have certain other judgment.
Yes, which section? You're referring to which section?
Yes, ma'am. First citation is your lordship.
No,
state
no,
of care-
section.
Yes, kindly come to paragraph 4, my lord. Section 43 D5 of the UAPA Act.
Yes.
If your lordship will kindly come to UAPA Act, section 43D, subsection 5 is the only bar. If it is attracted, then only then I am not entitled to pay. Kindly come to section 43D5. Notwithstanding anything contained in the code, no person accused of an offense punishable under chapter 4 and 6 of this act shall, if in custody, be released on bail or on his own bond unless the public prosecutor has been given an opportunity of being heard on the application for such release, provided that such accused person shall not be released on bail or on his own bond, if the court on perusal of case diary or the report made under section 173 is of the opinion that there are reasonable grounds for believing that the accusation against such person is prima facie true. Number 6, the restriction on granting of bail specified in subsection 5 is in addition to the restriction under the code or any other law for a time being in force on granting of bail. Number 7 is notwithstanding anything contained in subsection 5 and 6, no bail shall be granted to a person accused.
It is not applicable.
Yes. Now your lordship will kindly come to the judgment I have cited, my lord, 2011, State of Kerala, my lord.
Yes.
Your lordship will kindly come to paragraph number 4. May I read, my lord? That is there. On the other hand, the case of the respondent as disclosed in the counter affidavit filed before us is that even according to the prosecution case, the respondent was not one of the assailants as is not named in the FIR. In para 13 of the counter affidavit, the respondent has stated that the attack on Professor Jacob is a crime which is to be condemned. However, as a pretext to the investigation, the police has lashed out a reign of terror on innocent people of the minority community. People who were totally innocent or even had no knowledge of the crime have been falsely implicated. 55 persons have been made accused in that crime. Many residential houses, malls and offices raided and searched, and even minor children and women were cruelly tortured both physically and mentally. Holy books and other religious books were thrown out, seized and taken away and bundled in police stations. Warlike atmosphere was created in mosques, daily prayers were disrupted, men illegally detained and physically tortured in custody, and false cases booked against innocent. Now your lordship will come to paragraph 8, my lord. Now your lordship will please to see paragraph 8. We are presently only considering the bail matter and not deciding whether the respondent is guilty or not. Evidence has yet to be laid and the trial yet to commence. Hence, the prosecution is yet to establish by proof beyond reasonable doubt that the respondent was a part of a conspiracy which led to the attack on Professor so-and-so. The case against the respondent is very different from that against the assailant, alleged assailant. There is no allegation that the respondent was one of the assailants. We are opinion that at this stage, there is no prima facie proof that respondent was involved. That is the thing, my lord, in the crime. Hence, the proviso to section 43D5 has not been violated. The respondent being so and so, ultimately in this case, my lord, when they could not show that my link to the date of the incident, my lord, and I was one of the person, my lord, who was involved in the conspiracy to let
There
the
are
incident.
materials here to that
My-
effect.
Only phone call, my lord.
Yes.
Only phone call, that is CDR analysis.
That's right.
CDR is,
We are rightly, as you have pointed out, we are considering the question of bail.
yes,
Whether this phone call should be a good basis for conviction or not, is for the trial judge to decide.
yes,
Whether at this stage, prima facie, can it be said that there is absolutely no connection?
yes, my lord. That another judgment, your lordship will kindly say, CDR has to be linked to the date of the incident
No,
because,
that's what we are saying. You are referring to the division bench. judge.
yes, yes, ma'am,
Division bench.
2021.
This is with regard to the findings of the in the trial. Whether these
My
is
lord, kindly
sufficient,
say,
whether this is sufficient lead to a conviction, we are not required to return that finding here. We are required to see whether for the purposes of investigation, will it impede if the persons are released? That's all.
We are not sought any custody, my lord, from the very beginning. And as per the IO, my lord, forwarding report, may I again reiterate, my lord, they sought custody as one phone call. My lord, kindly see, my lord, allegation is receiving a phone call.
Where
after-
are the where are the statements of these persons? Statements?
Of the lordship, accused person lordship.
Ah.
I have flagged it lordship. I
Being a, my lord, villager, my lord, if
their
somebody
involvement
comes,
is there lordship, full involvement there. Materials are
this is not, my lord, section 212 IPC is also there, harboring, my lord. Harboring is a bailable offense, my lord. Their allegation is only harboring, my lord. Harboring.
When did the incident take place?
On 6th of April, my lord. Oh, sorry, my lord. 16 April.
24.
lordship.
16 April 2020.
24.
Yes. When they are coming from Sanglang district to Chinchikia Margarita.
It is 70 days lordship, it is 90 days offense.
And my lord,
I mean,
my lord, very much important is that on 18/4, while they are hiding in the village, my lord, if somebody comes and asks, give a phone call and asks where is the route to go to the, from Sanglang to, my lord, cross the border.
So he's not somebody, he's the fellow who's involved in the incident. He's not somebody, he's not a tourist who is lost in the jungle.
No, no, my lord, as a general villager, my lord, your lordship kindly consider.
All right, we'll pass orders.
My lord, there is one more judgment I want to say
Yes.
on section 10 of the UAPA.
Yes, please.
Although that is not affected, my lord, that mere membership or
But
mere,
that has been reversed subsequently.
no, this is holding the field, my lord. That Orup Bhuiyan.
Justice Kaju's judgment.
No, Kaju and Gyan Shuddha Mishra.
I think that has been reversed subject to correction.
That is, I have, my lord, seen that.
Anyway, you give it to us. We'll have a
Yes,
look.
my lord. Because, my lord, one more thing, my lord, they have stated clearly that we are only help them to escape from the village to cross the border and reach
So
them.
the question now is to examine whether are they involved in this conspiracy. Are they involved in the conspiracy or not? That's all.
Now, from the 164 statement, I have an your lordship is not a single whisper. Kindly see 164 statement. Your-
The 164.
I have an my lord.
So let us see from the
Page
then.
44.
Is it available here?
Yeah, I have an my lord. In my bail petition. Surprisingly, my lord, even the phone call which we have received, my lord, that belong to one of the villager women. Her husband says that he is in an outfit. So what was the conversation? What was the thing or what was the requirement? Nothing is there in evidence. Merely receiving a phone call, my lord. Sometimes happen, my lord. A villager receive an unknown call. And on that call, if anybody is, my lord, associated with an unlawful
Phone does not
organization.
belong to you.
No, they have called me.
No. Whose phone is it?
One phone belong to me, but I have not called. Somebody called on 18th of April after the incident. And one, your lordship, I have shown in the report, police order, John Hakum, my lord, who was providing the logistics. He was arrested and interrogation was sought for against him. Only allegation against us is that as
Has he been
because
granted bail? Is he granted bail?
no, he is the main suspect. But our is distinguishable, my lord. My case is that our is distinguishable. As a villager, if somebody give a call, my lord, I have not called back. No prima facie evidence. On 18 April, after 2 days of the incident, if they call and ask for a route to go, without knowing if they provide it, my lord, can I said to be a member of that association or organization, my lord? And even that association or organization is also not named. Our detention, not by the, my lord, police, is that we may escape from our village. Kindly see the ground of 164 statement, your lordship will find there are 4 witnesses from the same village, man.
No, 164 you said.
Yes.
164 is there.
164, Lordship.
You given me 161.
Because
Lordship, I'll flag it and I'll.
You give it to us.
Lordship.
because they are saying, man, one witness that phone belongs to her and her husband has used it and called to one of the. That is the thing, man. These are village people, man. So they have to be linked to the conspiracy on proof in trial, my lord. That judgment I have just now, your lordship, I have given.
That is in terms, that is at the time of trial, Mr. Counselor.
That's why, my lord, prima facie, our
Prima facie,
custodial,
because the matter is still under investigation, how will the judgment be applicable here? The judgment was rendered on the basis of the evidence available.
no, my lord, so far the witnesses they have examined, 164 also, it does not say regarding anything against us.
Yes, where is 164?
My lord, kindly take my page 144 of bail petition. Shiva Tasa is the
144.
164 statement.
No, page number?
Page 45. Page 44 is the list. Page 44 is the list of witnesses.
He is a witness.
Yes, ma'am. Kindly see, madam. Page 45. This is Shiva Tasa. He was carrying, my lord, the ration, and he was being made an official witness prior to the incident, my lord. Nobody, this statement witness also did not implicate. Kindly see, my lord. My lord, the lordship will come to page 48. That is one of the witness, my lord. Perhaps his phone number they have used and call it, my lord. This witness.
Not here?
Lordship. I've got one, Lordship. No.
You go through it, we'll take it up in a while. Go through it.
Lordship.
Yes, after a while.
Lordship, there is only one of 164. That is not the accuser. That is the co-accusership.
You go through it,
Lordship.
take it up. Go through it properly because
Lord.
the writ petition he is, bail petition, he has enclosed 4 or 5 of them. How is it not there?
And we have obtained certificate. I have the certificate.
We'll call it up in a while.
Lordship.
May I please, Your Lord?
Yes.
My Lord, 439 application, my Lord. Offence alleged under section 376 and 307, those are the non-bailable offences. This petitioner, my Lord, is about 84 days in custody till today. And my Lord, as for the affair, my Lord, it has been stated that, my Lord, the victim and my Lord, the petitioner, they had a love affairs for about 1 year, my Lord. And there, my Lord, some breakup was there, my Lord. Then this affair was lost, that he tried to rape, and my Lord, that she was assaulted. So, my Lord, considering my submission before your Lordship, my Lord, considering the period of detention, you will face the trial, my Lord.
Yes.
Lordship, 164 and 151 is here, and the medical report is there, Lordship. And otherwise, Lordship, from the incident took place in a lodge. The witness of the receptionist, that is also there.
Why is charge sheet not filed?
Such is not filed.
Why?
Lordship, it is 90 days, Lordship.
Why is it not been filed?
Lordship, it is the period is 90 days, Lordship, maybe may not be.
What? How many days today?
84 days.
Then?
My submission before Lordship, my Lord, he will face the trial, my Lord, if he is seated. Considering that, my Lord, that the victim already had 164 statement already recorded, my
Let us see.
Lord.
You come back on 11th.
My Lord,
You come back on 11th.
then it will be, my Lord, more than 90 days.
Why charge sheet has not been filed for 84 days? Where is the forensic report has come? Some
No,
forensic
no,
report
Lordship.
was called for.
That was not, Lordship. Only the medical report is there, the medical examination which was done.
Where is the medical report?
Lordship, that was tag marked the opinion part.
Where is the medical report?
But
Hmm. What is the age of the person, victim? Age of the victim?
He has lost the affair, my lord, in the
age 20 years, Lordship.
Where do you say it?
Lordship, it is in the forwarding, in the petition that is there. He is a major.
Heard, Mr. PM Chaudhary, Mr. An APP for the state. This bail application is filed by the petitioner for bail as he was taken into custody on 11/4/2024 in connection with the RS case number 124/2024 under section 12. Section of the pursuant to an FIR dated 10/04/2024 lodged by the informant making allegations against the petitioner of forceful assault and trying to force himself on the victim. As well as assaulted her on various parts of her body. So his FIR was accordingly registered as Jorhat PS case number 124 of 2024 under section 12. So petitioner was taken into custody with effect from so date and has remained in custody till date. So the bail petition on behalf of the petitioner before the additional session judge was rejected on 7/5/2022. So the counsel for the petitioner submits that there is an affair between the petitioner and the informant for last several years. And because of certain misunderstanding, the petitioner, the informant has lodged the FIR. So it is submitted that no such acts were performed by the petitioner as alleged in the FIR. That CD in the matter was called for. Whereas the honored APP has produced the CD along with the medical report. Perusal of the CD, perusal of the medical report reveals that there is no finding of rape or forceful penetration in the body of the victim. So when was the incident? When was
10th,
the-
my lord.
Huh? 10. The incident occurred on 10/4 and the medical report is dated 11/4/2024. So the 164 statement available in the case diary reveals that there was some relationship between the petitioner and the victim girl. So there were, however, statements that the petitioner has taken photograph of the victim in compromising position and had threatened to circulate these photographs and had also issued threats causing facing dire consequences on the relatives, including the parents of the victim. So, the case diary shows that investigation, the matter is still being carried on. From the case diary, there is no from the case diary, it is seen that there is no entry in the case diary to reflect that further custodial detention of the petitioner would be necessary for concluding the investigation carried on in the present case. So, charge sheet has also not been filed, although petitioner has been in custody for about 84 days. So, considering all of the above, including the period of detention, the court is of the view that the petitioner is entitled to be granted bail and is accordingly granted bail subject to execution of a bail bond of rupees 50,000.
20,000, Lord.
20,000. All right.
CGM Jorhat, my lord.
CJM Jorhat. Bail petition is accordingly allowed. CD return.
I'm obliged, worship.
Lordship, CD not received, Lord.
Coming from
Jorhat, Lord.
Jorhat,
Moriani Police Station.
Moriani. Then
12th, my Lord.
12. It is submitted by the learned APP that CD call for has not been received. Considering the urgency expressed by the counsel to the petitioner, lists the matter on 12th of July in the vacation court available.
439 application lordship, petitioner has been arrested on 12/5 under section 66D, E and 67A of the IT Act and 387 the IPC. Already is in custody for 52 days. Mandatory period is 60 days. FIR at page 10, Lord.
Page 10.
Yes.
Yes. Yes.
Married. Sir, I would like to inform you that I am Sri Mollika Deka, village Sorthebari, Junkar Chup, PS Sorthebari, Borpeta. In connection with work, now I am staying at Lokra, Kepinjal. For the last 3 years, I am in a love affair with Dipu Das, and our family knows about our relationship. He is staying at Hyderabad in connection with his job. His address here is son of Pratap Das, village Borpeta, Bishnupur, PS district, so and so, so and so. He introduced me as his wife and kept me in a rented house at Boragaon, Guwahati. After staying for some days at rented house, he again went back to Hyderabad, and things were going on like this. During the time of love affair between us, we had physical relations on many occasions, photos of which he kept in his mobile. When he was staying at Hyderabad on video call, he used to see my private part, and on many occasions, I had to give him private photos because I want to keep our relationship alive, for which I used to do whatever he said. But from some days, quarrel took place between us because he now loves another girl. On many occasions, I tried to make him understand, but he did not try to understand. Instead, he threatened me to viral my private photo, and he shared my private photo via WhatsApp with my friend. Not only this, I came to know that he created a fake account on Facebook in my name and sent some message. He also took around 50,000 from me by showing various reasons, sometime in cash or sometime via online. His atrocities are increasing day by day, and he threatened me and my family with direct consequences if I inform this to the police. Therefore, there is a threat to my life, and if in future anything happened to me, he will be responsible. What was happened to me had shall not be happened to any other girl, and it is my humble prayer before you, sir. This is the FIR. The case of the petitioner is that it is a fact that there is a love relationship between the petitioner and the informant. At the initial stage, he stated that she is single, but subsequently the petitioner came to know that he is a married woman and have a children. So therefore, he stopped the relationship with her after this affair has been lost. Also.
What is the stage of investigation?
My lord, here investigation is going on, not completed, my lord. As per my lord, CD is also available here, my lord. And from the statement and 161 statement of the witnesses, my lord, it reveals that he has filed my lord, some neck photo to his friend, my lord, some of the friends, my lord. Even he also admitted, my lord, in his statement, my lord, he admitted that he has given some viral, my lord, some neck photo, my lord.
Also, already 52 days is over. 60 days is mandatory period. Other sections are available.
Which sections are available?
66D and 66E are available. 67 is 5 years and 387 is 7 years.
66 D and E.
E are available.
Available.
And 67A is 5 years.
What is 67A? ITA.
ITA.
ITA. দেখুন এখন
Punishment for publishing or transmitting of material containing sexually explicit act, etc. in electronic form. Whoever publish or transmit or cause to be published or transmitted in the electronic form any material which contains sexually explicit act or conduct shall be punished on first conviction with imprisonment of either description for a
Here,
term.
notice on the victim is not required.
No.
Not required.
Not required. 67A.
67. First offense, it is 5 years.
First offense 5 years
and
subsequent offense is 7 years.
7 years.
And as per the allegation made in the FIR, 387 doesn't come.
IPC.
Lordship, 387. I think.
Yes.
Putting person in fear of death or of grievous hurt in order to commit extortion. Whoever in order to committing of extortion put or attempt to put any person in fear of death or grievous hurt of that person to that person or to any other shall be punished with imprisonment of either description for a term which may extend to 7 years and shall also be fined. So yeah, as per the allegation, this 387 doesn't come.
My lord, one IO note I have tag mark, my lord.
Hmm.
Here also that he is also threatening the, my lord, complaint, my lord, for withdrawal of the case, my lord. That part is also there. I have tag mark, my lord, IO note,
IO note.
my lord.
But he is in custody.
At present.
How will you threaten?
My
Yes, Lord.
He's in custody.
earlier.
Considering the length of detention, let's say already 52 days.
You come back on 11.
In the meantime, let's say mandatory will be over
Just one day. It will be over on which date?
on 11th. It will be over.
On 11. You come on 11.
Considering lots of allegation, this allegation is a daily worker working at Hyderabad, and it is she is a married lady. That is reflected in the forwarding report. Lord. Kindly come to look. Page 14, annexure 2. Lord.
One.
She is a married lady and she is maintaining a relation with the petitioner.
Yes. Forwarding.
Forwarding, let's say, page 14, annexure 2. Lord. Bottom, Lord.
Yes.
Ground of arrest number 4. From the attitude and body language of the accused person, it may be assumed
Page,
that
page number 14.
14. Lord.
Then ground of arrest.
Ground of arrest number 4.
Number 4.
From the attitude and body language of the accused person, it may be assumed that he may kill the victim woman to take revenge. Further, the victim woman have stated that she has a minor son of 8 years from her first husband, whom will be kidnapped by accused person at any time to take revenge. Therefore, it is seen that the accused person has disobeyed the terms and conditions under section 41A of the CRPC. There is a married woman, Lordship.
You come back on 11. Let us see. Give them some time, whatever is there. Otherwise, by default, you'll get a bill. By default.
Length of detention only 52 days, Lordship. Consider that, Lordship. He's a daily worker at a medicine company in Hyderabad.
We don't understand why you have not proceeded to file the FIR. Why? What more is required?
My lord.
Already my phone
And
has
you
been
are making
seized.
a statement that he is threatened. How he is threatened when he is in the custody?
My lord. No, that from IO, my lord. I don't know.
No, how the IO has permitted him to threaten?
And my phone was seized long back, Lord.
Yeah, you come back on 11.
Also considering the length of detention, Lord, 52 days. Lord.
11. You'll be over on that day. Let us see what happens. You come back on 11.
My lord. CDB written, my lord. Or
CD will give it to you. You retain it.
My lord. My lord.
Come back on 11. Allegations are there.
My lord.
Not
Allegations are there, Lord. And
allegations
it is
are
an
there.
admitted fact that she is a married woman.
Maybe.
And maintaining a relationship with the boy.
No, is that her fault alone?
He also admitted in
Is that her fault alone? Then
Then?
so you come back on 11.
My lord.
By that, if they don't file the charge sheet, it
My
will
lord.
get over.
My
Heard learned counsel, matter be listed again on 11th, the next available vacation bench. CD, the retained
My lord.
by the learned APP.
No, my lord. That no run. I will send back, my lord, for if there.
What is
If sent back, then again.
Then how will it come?
It will come, my lord. It will come, my lord. I will talk to IO, my lord.
Again, it will be difficult. I have to withdraw this application before
I will talk to IO, my lord. If
Hmm?
what I'll talk to IO, my lord, over telephone, my lord.
Why don't you retain it? Why don't you retain it? We'll
Yes.
direct you to
My
retain
lord,
it.
my lord, my lord,
CD be retained till the
Ma'am.
next day
Ma'am.
by the learned APP
my lord,
to be produced before the court again.
my lord.
Obliged. There are reasons why we have deferred, but perhaps the benefit of 90 days you'll get it, 60 days.
60 days.
You'll get it on 11.
Fine.
Meet your lordship.
IA.
My lord, this IA has been filed because of a very urgent situation, my lord. What happened, my lord? The writ petition was filed. Bringing to your lordship notice the fact that the special judge Assam, my lord, that court was not constituted in terms of section 3 of the special, my lord, of the Prevention of Corruption Act. And it was constituted under the, my lord, Assam Special Court Act 1950, and therefore it doesn't have jurisdiction to try the offence. And my lord, in that, my lord, writ petition, it was listed on 3rd of June. And the learned counsel for all the respondents, my lord, prayed for time to file affidavit in opposition. For 1 week, 10 days time was granted, my lord. The date was fixed on 14/6. Then, my lord, on 14/6, again, my lord, the prayer has been made, and because of the holidays, my lord, the time has been granted till 3rd of, my lord, the 16th of July. Now, what happened in the meantime? This particular trial, my lord, which is a case of 2017, the argument of the defense, all the defense, my lord, that has been over yesterday. And the today is fixed for the submission reply on behalf of the my lord prosecution. So, my lord, any moment the matter will be decided. Now, my lord, the prayer that has been made in this I is that, my lord, prayer your lordship will kindly come to the prayer. Prayer is
No,
very, my
first
lord.
tell us why you filed the writ petition.
My lord, writ petition was filed because, my lord,
for seeking transfer.
yes, my lord, this has to be transferred to a court constituted under section 3 of the, my lord, the Prevention of Corruption Act. And the, my lord, court, the special judge Assam, my lord, that has been constituted under 1950 Act, Assam Special Court Act 1950, and therefore, my lord, it doesn't have jurisdiction to, my lord, try the case. That is the, my lord, submission. If your lordship kindly comes to the, your lordship may kindly take up the PC Act just to get prima facie, my lord, I satisfy your lordship. Take on, Lord. Take on, Lord. My lord, Prevention of Corruption Act came into being, my lord, in 1988. And your lordship may kindly come to section 3.
Yeah.
Section 3, power to appoint special judge. The central government or the state government may, by notification in the official gazette, appoint as many special judges as may be necessary for such areas or for such case or group of cases as may be specified in the notification to try the following offences, namely any offence under this act. B, any conspiracy that may not be relevant. 2, a person shall not be qualified for appointment as a special judge under this act unless he or has been a session judge or additional session judge or an assistant session judge under the Code of Criminal Procedure. Now, your lordship may also kindly read the section 4. Cases triable by special judges. Notwithstanding anything contained in this Code of Criminal Procedure or in any other law for the time being in force. This is important, my lord. The offences specified in subsection 1 of section 3 shall be tried by special judge only. So, my lord, it has to be only by, my lord, a special judge constituted, my lord, appointed under section 3.
Notwithstanding any other.
And, my lord, it also says that it is notwithstanding any other law for the time being in force. And, my lord, so far as the Assam Special Court Act is concerned, my lord, 1950, that is still in force. Therefore, after, my lord, coming into effect of the Prevention of Corruption Act 1988, it is only a special judge, my lord, special court constituted under section 3, and, my lord, a special judge appointed, my lord, under section 3, my lord, it will have jurisdiction to try the case. Now, my lord, this is a matter to be decided. This is a point of law which cannot be decided, my lord, without an affidavit filed by the government. Affidavit has not been filed. In the meantime, my lord, as I have already said, my lord, the matter has been tried. May I also, my lord, place the Assam Special Court Act, maybe on record. Okay.
Yes.
Here, your lordship will find, my lord, section 2. In this act, unless there is anything repugnant in the subject or context, the court means the CRPC. D. Special court means a special court of criminal jurisdiction constituted under section 3. Section 3 of the, my lord, this act. Then section 3 say, and my lord, B, special.
So what are you trying to say, that under the PC Act, no special court is constituted?
No special court has been constituted under, my lord, section 3, section 4. And therefore, my lord, it has to be tried by a court, my lord, constituted under section 3 of the PC Act.
Where is the trial going on now?
Before the special judge has come, my lord. And this is the last date, my lord. It will be, my lord, today it will be reserved for judgment. And the only prayer I make, my lord, if your lordship takes up my IA, only prayer is
Your
that,
prayer in the writ petition is that it should be transferred to any court
yes,
formulated under section 3.
yes, my lord.
And indeed you say that no court has been played.
No
So in essence, what
Lord,
are you submitting?
there is one court, in fact, my lord, there are 4 courts perhaps. One court, my lord, only for the CBI cases, my lord. But this is a case which is, my lord, investigated by the state police. But that court, my lord, which are, my
The grounds you can take in appeal if you want.
no, my lord, my submission is, if your lordship will kindly see my prayer in the eye. My prayer is, my lord, very simple. I do not want a stay. I do not want that, my lord, no conviction order should be passed against me. I do not want any order. Only one observation, my lord. My prayer is that the trial, my lord, the final result will be subject to the result of the case. What will be the effect of this, my lord? In the event, my lord, I am convicted tomorrow, I'll go to jail, my lord. I do not say, my lord, do not send me to jail. Only I say that whatever happens, my lord, that will be subject to the final outcome of this case.
In the event the judgment is against you,
yes,
you go in jail,
yes,
what is your remedy?
Then, my lord, an appeal will be there for on other grounds, my lord.
So in this appeal, can you not take the question of jurisdiction?
No, my lord, my submission is, my lord, in the event I am convicted and sent to jail tomorrow, my lord, I do not say, my lord, your lordship will stay there, but, my lord, that will be subject to the final outcome of this writ petition. In the event, my lord, my writ petition is dismissed, then, my lord, nothing happens. In the event, my lord, your lordship finally comes to the finding that, my lord, yes, this court doesn't have the jurisdiction, then, my lord, this order will protect me, my lord.
How will it protect you unless you...
Section 5, my lord.
No. Then...
Section 5 of
yes,
this,
what has happened to
My
your
lord,
affidavit?
actually, I'm just pointing
because,
out
I
one.
don't know, let me complete.
Yes.
Because, my lord, that will be a judgment in the event, my lord. Because there are 2 possibilities. Your lordship may reject my writ petition.
Raise the question of jurisdiction.
My lord, that is what I'm raising at presently.
Before the trial?
Before the trial, my lord. No, trial is complete now.
Complete?
Yes.
At what stage is it?
My lord, yesterday, my lord, all the accused persons, lawyers, my lord, they have concluded their argument. Today is fixed only for, my lord, the reply of the, my lord, prosecution. And it will be reserved for judgment.
Reserved for judgment.
My lord, thereafter it will be reserved for judgment, and judgment can be passed any day, my lord. And only one observation that, my lord, this will be subject to the result of the case.
I object.
In the event, my lord,
I strongly object it.
Your lordship will kindly come to, my lord, section 5 of the, my lord, PC Act.
PC Act.
Section 5 is, my lord, procedure and power of the special judge. Your lordship may come to subsection 5. A special judge may pass upon any person convicted by him any sentence authorized by law for the punishment of the offences of which such person is convicted. Now, my lord, if the court ultimately your lordship holds that the court doesn't have the jurisdiction, my lord, that will be, my lord, an order passed, my lord, without jurisdiction. And in fact, my lord, what happens? Because, my lord, only thing they want to show, they need to show before your lordship is that, my lord, that this court, special judges court, has been constituted under section 3 of the my lord, PCA.
Your writ petition is pending.
My lord.
Have you filed the
Writ
affidavit?
petition is pending, that is fixed on, my lord, 16th of July this month.
Have you
I have
filed?
yes, I am on behalf of the High Court. I have to, my lord, take the all the this is 1953, my lord. Your lordship kindly see that section 26, my lord. Of my lord, that act, my lord. PC Act.
PCA.
Yes.
I'm grateful to my learned friend that he has brought to your lordship notice this fact. I'll make submission on the later topic.
Because today, my lord, what urgency arise, my lord, to list this case before this honorable court in a vacation case, my lord? When the matter is fixed on 16, my lord, and court was granted time to, my lord, file affidavit. And prima facie, there is a, my lord, order, your lordship kindly see section 26, my lord.
Every special.
And in fact, my lord, at the time of, my lord, notice, my lord, no intimate order was rejected, no intimate order was passed, my
It
lord.
is not rejected. You have asked for time, 1 week time.
Then, my lord,
You asked
then
for
I
3 weeks time.
strongly dispute, my lord, on a fingerprint case, my lord. Your lordship kindly pay para 5 of the, my lord, their mispetition, my lord.
No, you are.
No, your lordship kindly, my lord, I'm replying to his submission, my
You
lord.
are referring to section 26.
Yes, my lord. Yes, section
Yeah,
26.
according
No, my
to
lord, before
section
that, my lord, he is giving an allegation, but that's why, my lord.
We will go into it.
Court was not inclined to pass any interim order. That is his statement, my lord. That is not my statement, my lord.
We have seen that.
My lord. No, your lordship kindly. Special judge appointed under section 46 of 1952. Because, my lord, this amendment Act 1952 is, my lord, came to force, my lord, not 1950, my lord. This special judge, my lord, the special judge appointed under section 46 of 1952 be special judge appointed under this act. Every special judge appointed under this Criminal Law Amendment Act 1952 for any area in this holding office on the commencement of this act shall be deemed to be a special judge appointed under section 3. So, lordship kindly see not under section, my lord, Amendment Act 1950, my lord. So clearly mentioned in that deemed to be a judge of the, my lord, under section 3. This is the act, my lord, now your lordship kindly see. So that's why, my lord, this is the notification in 1952, my lord. So I have to collect this, my lord. That's why this take time, my lord. I have already collected, I will file affidavit, my lord. Not under 50, my lord. Their whole case is that, my lord, special court, my lord, special judge not appointed under section 50. Yes, correct, not under 50, my lord. 1950, my lord. This is 1952, my lord. That is the notification, my lord.
Why are you insisting?
My lord, your lordship, and again, my lord, I am submitting. They have recourse, all, my lord, all recourse. They file a petition before up to Supreme Court, my lord. Even in fact, my lord, Apex Court clearly stated, my lord, that this is the order passed, my lord. My lord, they are one and again after filing cases, my lord. Even, my lord, why? When cases fixed for 16, my lord, why, my lord? They have, Miss case was moved in on vacation period, my lord. Court was granted time till that, my lord. Earlier, transfer petition also dismissed, my lord.
My lord, if your lordship permits, my lord, I'll read section 26 and I'll show that this has no application. I'd also would like to point out that, my lord, he's appearing for the High Court and he's, my lord, arguing for the prosecution.
No, I am not. I'm placing the case, my lord. No, your lordship kindly, because they are clearly blaming me, my lord. Blaming me. I have taken time and again. That's why it is delayed. And because of the delay, they have filed this. My lord, court has granted time. And when, my lord, my submission before your lordship, when, my lord, at the time of motion, my lord, as my lord, interim order was rejected, thereafter, by way of filing, my lord, by filing a, my lord, and miss case, my lord, paying for interim order, it is amounting to a review of the earlier order, my lord.
So there is no rejection order.
But they have himself said, my lord, they paid, my lord.
But
They paid.
the order does not reflect the interim order.
But they said, my lord, that is not inclined to pass. That is their statement. I am going. When there is the admission, there is no need to prove, my lord.
Not inclined may not strictly mean rejection.
But
not inclined.
But which was not granted in earlier, my lord, that by way of miscase, they can be done, my lord.
No, that's what.
That's why, my lord, let the matter be fixed on. I will file the affidavit. Let the matter be fixed on.
Be granted once it is rejected.
My lord.
But there is no order for rejection.
My lord.
This is only a statement saying they're not inclined.
Yes, my lord,
Does
not
it mean
inclined. Since
rejected?
not inclined, by way of, my lord, filing a miscase, my lord, that will not be, I think it will not be proper, my lord.
Yes.
That prayer, in prayer is in respect of my lord, the main writ petition. Now, my lord, the situation has arisen for filing this particular.
No, we are asking you only one
My
question.
lord.
You are asking for an observation from this court.
Yes, my lord.
Now, how will it affect you if if this writ petition, let us say hypothetically, is allowed? Does it stop the court from coming to a finding that this judgment rendered by the trial court in view of whatever you have
My lord,
urged
unless
will have no effect because the court was not constituted as per the act? So why this observation now? Why do you want an observation?
because that observation is necessary, my lord, because I am challenging the jurisdiction of the my lord, the special judge.
That's right, which will be heard and taken up in the writ petition.
My lord, the observation will not, my lord, affect the prosecution.
We are asking you why you want an
Affect me
observation.
in the sense that, my lord, in the event I am convicted tomorrow, my lord, and eventually, my lord, this petition is allowed by this honorable court.
Right.
Then, my lord, the entire
Assuming we decline to give you that observation,
my lord,
tell us, is there a bar for the writ court to allow the writ petition?
my lord, that is the observation I require, my lord.
What?
That, my lord, this will not be a bar to, my lord, pass on.
Why that observation is necessary?
That observation protects me, my lord, in my humble submission.
Well, it would have an undue pressure
When
on
your
the judge.
writ petition
Because, my lord, that will be an order without jurisdiction, my lord.
Well, I have
There is an order. There is an order fixing the matter on 16th.
My lord.
You urge whatever you want to urge before the court
On 16th, my lord.
on 16th.
Till that time, your lordship will protect me, my lord.
Protect you as from what?
From, my lord, the protection that, my lord, the any judgment as a
That
conviction or
will amount to allowing you your final prayers. That is the final prayer that you want.
no final prayer is, my lord, for transferring to appropriate court, my lord.
That is your basic argument,
Yes.
is that there is no court constituted under this provision.
Yes.
No special court. So where is the question of allowing your prayer to transfer it to an appropriate court? Particularly in a matter where the trial has proceeded and according to it has concluded.
My lord, the under section 3 of the PC Act, my lord, courts have been constituted.
Hmm.
In Chanmari, your lordship knows, my lord, there are a special judge and my lord.
But according to you, this particular court is not a court constituted under this act.
In fact, my lord, that was yes. This is not, my lord, constituted under. My lord, your lordship will kindly, my lord, may I draw your lordship attention to one notification I have given after filing of this, my lord.
We are not inclined to pass any interim orders like this.
My lord, your lordship will kindly say, my lord, after I file this petition,
We
my
may
lord,
issue a notice making it returnable on 16th.
my lord, only thing, my lord, they need to produce is that to show to the court that this special judge's court has been constituted under section 3.
Then you take it up before the court when the matter is listed on 16th. This interim order that you are asking for,
no, my lord,
it's not an innocuous observation.
My lord, my submission before your lordship is that, my lord, unless there is an order to that effect, my lord, that this will be subject to what final order.
Then the question would
my
be,
writ petition will become
then the question would be why this prayer was not made in the before the court earlier, at the time you filed.
At the time of file, we have got the prayer, my lord.
Well, why was it not pressed?
My lord, they said that within 1 week we are filing the affidavit.
Very well. If it is not pressed, you agreed to an order on the subsequent date.
Okay. In fact, my lord, we asked for stay. In the main writ petition, we asked for stay. And my lord, it was submitted that we are filing affidavit within 1 week. And therefore,
First date is on 3/6.
Yeah.
Then it was fixed on 14/6.
Yeah.
14/6, time was allowed to list it on 16/7.
Yeah.
There was no objection recorded here.
No. In the meantime, my lord, the arguments were going on in the trial court.
Yeah.
And it has concluded, my lord, yesterday.
Whatever it may be.
In fact, my lord, your lordship will kindly see that notification I have given after filing of this writ petition, my lord, it has been realized that, my lord, it has not been constituted and, my lord, many cases have been transferred to the other court. That notification I have given, my lord. Your lordship will kindly see because now, my lord, perhaps the people have become a little wiser. By this notification on 7 June, my writ petition is earlier in point of time, my lord. Paragraph 2, your lordship will see all session tribal cases investigated by CBI now pending trial before the court of session judge Kamrup and additional session judge court at Kamrup can withdrawn from the respective court and are transferred to additional CBI court number 1, 2, and 3 as shown against each court in Annexure 1 enclosed herewith. And in the, my lord, list, your lordship will find, my lord, the cases of, my lord, 2014, 2016, 2019, all cases are transferred. Now they have become a little wiser, my lord, after filing of this writ petition. Otherwise, my lord, the authorities, government needs to produce, my lord, only one notification saying that, my lord, this special judge Assam has been constituted under section 3 of the PCA.
Where is your matter pending?
My lord,
Where is the matter pending?
Special judge Assam.
special judge. Yeah.
Not in CBI court, my lord. But for the respondent number 2 and 3, I am appearing in this case. I have received the instructions. My affidavit is ready. Kindly, I'm about to file the affidavit on the reopening. On 15/7, I'll file. And the case is fixed on 16/7. In the mention memo, they have mentioned they have stated that if this interim order is not passed, IA is not allowed, their case will become the petition will become.
That is my only apprehension, my lord. My writ petition.
My respectful submission is that has already fallen from your lordship. Lord. My respectful submission is the Lord. But lordship has
It's not, certain facts are not clear. Did you press for an interim order?
That is what I am doing today, my
No.
lord.
When the matter was filed, did you press for an interim order?
That interim was order was for stay, my lord. I have not asked for now stay, my lord.
Did you press for an interim order?
My lord, when it was argued, my lord, it was submitted, we are filing affidavit in a week.
No, you did not press for an interim.
I praised the petition, I praised that, my lord.
If it is pressed, then it was rejected. If it is rejected, then you have to go in.
No, court was not inclined. I say, my lord, court was not inclined because they said we are filing the affidavit in a week.
we had time.
Okay, heard. Learned Senior Counsel, Mr. M.K. Chaudhary, assisted by Mr. S. Das. Also heard Mr. D. Nath, Learned Senior Government Advocate, appearing for
Respondent
the
number
opposite
2 and
party,
3.
respondent number
2 and 3.
My lord, may I
Two
be
and
permitted to, my lord, place a judgment?
Mr. T.J. Monto, appearing for respondent number 4 as a standing counsel. M.S. S. Jahan appears for the respondent number 1. He wanted to place some judgment?
Yes, my lord.
Yes.
My lord, this is 1994, volume 6, STC, page 731. Supreme Court Legal Aid Committee versus Union of India. I'll, my lord, read only 2 paragraphs. Paragraph 11 to 14 are relevant, my lord. Your lordship, my lord, in order to save time, may I draw your lordship attention to paragraph 12.
Yes.
This takes us to the next question. This is a case under NDPS Act. When can a special court be said to have been constituted? The plain language of section 36 says that the government may, by notification in the official gazette, constitute as many special courts as may be necessary for such areas as may be specified in the notification. That is, my lord, perimeter with the, my lord, PCI. Therefore, the mode of constitution of special court is by issuance of a notification in the official gazette specifying the area for which each special court is constituted. Subsection 2 of the section 36 says that the special court will be a single judge court. Subsection 3 next provides that a person who has immediately before such appointment functioned as a session judge or an additional session judge shall be eligible to be appointed as a judge of the special court. Section 36, therefore, has 2 stages, namely, the first stage in regard to constitution of special court is by issuing a notification in the official gazette, and then comes the appointment of the individual or function as a judge of the special court. Therefore, as soon as the notification is issued under subsection 1 of section 36, the process of constitution of a special court commences, and it is only thereafter that the government can seek the concurrence of the Chief Justice of the High Court for the appointment of a judge of that court. As stated earlier, only a person who has worked as a session judge or additional session judge immediately before such appointment is qualified to be a judge of the special court. This is the plain language of section 36. Then section 13, but the question still survives whether the constitution of the special court can be said to be complete and effective only after the judge to preside over the court is appointed. The likelihood of a time gap between the issuance of a notification under subsection 1 of section 36 and the appointment of a judge to man the court has to be countenanced. This is evident from the fact that in this case, which shows that the notification under section 36(1) was issued on 4/1/91, and the notification appointing Sri Pathan to man the one of the two courts was issued on 6/4/1991. Can this special court be said to have been constituted on 4/1/91 or 6/4/1991?
So very well, this will have to be considered.
My lord, prima facie, my lord.
We'll issue notice now. We'll issue notice here.
My lord, the only observation that, my lord, otherwise my writ petition will become infructuous. My lord, that is my only apprehension.
Why are you apprehending that before 16 the judgment will be delivered?
That will be directed by this honorable court.
All right, then we'll have it on 11. You get your instruction.
11
11.
11 for me problem.
Sorry?
11 for me, I will be out of station.
Can be helped. There is urgency expressed.
No,
We'll
my
have to
lord,
give. We'll have to
kindly-
consider both sides.
agree, my lord. I take, but it is not a matter to be deal with, my lord, in vacation bank, my lord. My lord,
That is for us to decide. When there is a
No,
prayer
I will
made,
be
then
out of
we'll have to consider it. If the question raised is that the courts are not constituted as per the provisions of the Act,
no, my lord, that
then
is
there is no
absolute,
question
my
of
lord.
jurisdiction.
I have given, my lord, NF document. They can challenge it, my lord. They have not challenged this one, my lord. 1952 Act, my lord, it is. It is not
My lord,
1950 Act, my lord.
But our affidavit is
Our
ready.
affidavit is ready,
Let,
my lord.
let the affidavit.
Why your
come.
affidavits are not filed?
Well, during vacation, my lord, we have not filed because case is fixed on 16th of July. Well, on 15th on the reopening they will file. It is already fixed on lordship has
Why will
granted
you
us
file it
time.
on 15th if the case is fixed on 16th? What is the purpose?
Well, because the vacation is going on, my lord.
So
Because of the vacation, court has granted us 3 weeks time, my lord, and we are going to file the
you know
affidavit
the
before the next day.
gravity of the issues raised,
My lord,
Mr. Counsel.
My lord, IA has been filed. My lord, yesterday they have concluded their argument. Reply is to be filed by prosecution, given by the prosecution today. And now, my lord, they have said that ultimately, my lord, if any observation from this honorable court in my respectful submission, my lord, will be hanging upon the judge, my lord. It should be their intention is to keep it in the mind of the judge that while passing the judgment, it should play in his mind. That is what they are trying, my lord.
Court may clarify that, my lord, he can pass any
No,
conviction or
that will ultimately, in any case, my lord, if any order is passed, any observation, anything is passed, my lord, it will be on his mind, my lord, in the just to put a pressure on him, my lord, this has been done. My lord, otherwise, my lord, writ
No,
petition
but
has been
see, the question has to be decided whether the
Correct,
grounds
my lord.
urged
True. Lordship,
are sustainable in law.
true, my lord, true. That is
Your
there.
affidavit would have been a help.
Yes, my lord,
It's not on record.
I have received the instructions and I'll file the affidavit, my lord. I'll file the affidavit with the supporting notifications and all these things. I will file the affidavit, my lord. Lordship has granted us time, my lord. Kindly on 16th it is lordship in the I also.
My learned friend is, my lord, reading the mind of the special judge.
That is what they are doing.
There is an apprehension that in the event the judgment is delivered, whether the writ court will now be able to embark on this question.
My lord, lordship, the writ petition is pending. If lordship passes an order on 16/7, my lord, the consequences definitely it will follow. My lord.
No. Assuming the judgment is delivered, once a judgment is delivered,
Lord.
what will be the remedy available to the writ petitioner?
My lord, if writ is allowed, my lord, it will be
How can
nothing.
the writ be allowed? When the basic prayer is to transfer.
No, lordship is set aside. Kindly see, my lord. The prayer number 2, my lord. They have prayed for stay of the proceeding. Then alternatively direct the learned judge to directing the
Not to
learned
pass.
special judge some not to pass the
Then where
final.
is the question of setting aside? Because the judgment is not there.
Lordship, if the writ petition is allowed by passing an order, then my lord,
Allowed to
ultimately
what? Allowed in respect of the prayers made. What are the prayers here?
my lord,
he has prayed that it should be transferred and and there should be a
Once the
stay.
judgment is rendered, delivered, where is the question of transfer? Where is the question of stay?
Well, if
Where is the
the-
question of directing the judge not to pass the final order?
Malad, it is for the petitioner. He has made the prayers. Malad, if the petitioner made out a case, kindly see what is his case, Malad. Paragraph number 6, Malad. Paragraph 6 of his writ petition. What is his case, Malad? He said that the petitioner states and submits that after promulgation of the Prevention of Corruption Act 1988, a court constituted under Section 3 of the Prevention of Corruption Act alone shall have the exclusive jurisdiction to try the offences under the said act. Malad, then kindly see that petitioner submitted the judicial officer appointed under Section 4 of the Prevention of Corruption Act 1988 alone shall have the jurisdiction to try the offences. That means, Malad, the petitioner wants to argue that the trial which is going on in the court is non-est. In that case, why he has not paid for setting aside, Malad? He has not paid for that. It is don't keep prompting. You
We can prompt me.
no, that's true, but not to us.
Correct.
No. Your voice is too loud, Mr. Das.
I fail to understand, Mala, how will the
And Lordship has-
notification
Lordship
be
has-
released by this order
Lordship
that
has-
is paying now? Is it should be caused by?
And if Lordship
The
is
time
issuing
court
notice
can
in the IA,
send
notice
order.
in the IA to be taken on 16/7, let the notice be issued in this IA also, Malad. On 16/7, Malad, Lordship will pass the order. Lordship will consider. Now, how they know, Malad, that in the meantime judgment will come?
We don't know. That's why we are asking for protection. The judgment is delivered, my lord. Day-to-day trial is directed by the sum of the court.
No, I think we'll put up both these matters on 16. Because your prayers in the writ petition and prayers in the IA is the difference.
Yes, my lord. Because, my lord, in the main writ petition we had done many prayers. Now only an observation. And observation which
Observation like this can't be granted. List on 16th along with WPC numbers when respondents opposite parties are
in one observation
entitled to
that, my
file
lord, my writ
their
petition will not
objections in the
be
meantime. Sorry,
one observation that my writ petition will not be
we can't do that. We can't do that.
That's why
Once you have either you pray for stay of the trial.
that
Pray for the stay of the trial.
then, my lord, I can pray, my lord, praise the prayer, that prayer, my lord, because that is there in the writ petition.
So that is there, but you did not press it on the first days. That is what we are asking you. Why not?
My lord, it was praised, my lord, it was assured that within 1 week the affidavit has been filed.
Therefore, you have abandoned that prayer.
It's not abandoning, my lord. They are given, my lord. That prayer I can always renew, my lord, when the writ petition is taken up.
Mr. Counsel, you did not press the prayer on the first 2 days. You knew that there was a day-to-day trial going on. You knew what prayers you made in the writ petition.
Yes.
Yet you did not press on the assurance that an affidavit will be filed. Assuming that an affidavit is filed on the dates given, did you foresee that the matter would be disposed of on that date?
We did not, my lord.
Then
we did not. But now,
so
my lord, the
therefore,
things have happened, my lord. The arguments have been.
This is an afterthought. This is an afterthought.
Because of the subsequent development, my lord.
How can it be subsequent? You are conscious that it is a day-to-day trial.
Yes, my lord, but the argument of, my lord, there are many accused, large number of accused persons and large number of lawyers arguing, my lord. And those are concluded yesterday.
We can't pass an observation like this. What you're asking for is we restrain ourselves to say that perhaps it is not a bona fide submission. We can't pass an order like that. What is the effect of saying that this judgment will be outcome of the writ petition? On what context?
Otherwise, my lord, my petition becomes infructuous.
You have remedies, you have forums to take up your grounds.
This is the forum, my lord.
No. There are other forums available. You had an opportunity to press for a stay. If it was rejected, you have a forum for appeal. You did not press for it.
I cannot go on appeal because it was not rejected, my lord.
You did not press for it.
We did press, my lord.
No, that is your submission. You did not press because they You relied on their submission that affidavit will be filed.
Yes, within a week. my
Then
lord.
where is the question of pressing the stay? You did not press it.
No,
Therefore,
court-
no stay was
we said, my
granted.
lord, court was not inclined to, my lord, but
Mr.
it was not
Counsel,
rejection.
don't make you have to be fair to the court also.
My lord, I
You have to be
understand,
fair
my
to the court.
But at the same time, your lordship will kindly see, my lord, how it will not prejudice them, and my lord, the court will not be barred from passing any order.
Under what law are we staying a proceeding of a special judge, assuming it is constituted rightly, incorrectly, not correctly? What is the effect of that?
My lord, prime officer, I have
Your
satisfied-
challenge in the writ petition is for transfer.
Yes, to an appropriate
Then-
court, my lord. And the court has to be constituted. They can constitute it within a day, my lord. Any day.
After the arguments are over,
Or it goes to, my lord, the Chan Mari, my lord, by notification.
we don't know that. Therefore, we are giving you time till 16th. Let it come on 16th. Let them file their affidavits or whatever they want to do. You are free to press the matter.
Let it be on 11th, my lord, because I apprehend the order may be passed, my lord, in the meantime.
If it is passed, it is passed. What can be done? You have remedies ahead.
This petition,
You have remedies ahead.
this petition becomes interesting.
Maybe, but there are remedies ahead. We are not even.
Then your lordship will say, my lord, on the next that the interim prayer in the writ petition as well as this petition will be considered.
Let him learned counsel of the petitioner is permitted to press the prayers for interim made in the writ petition on the next day.
As well as this IAM.
In the IA. Your interim prayer is in the IA, not in the writ petition.
Yes. In the writ petition also, my lord, because they were supposed to
In the
file
writ
it.
petition as well as in the IA. List on 16.
Can it be 11th? My apprehension is, my
Can
lord,
be in 11 subject to no objections.
Let it be on 16, my lord. Lordship, let it be on 16, my lord. It is the date fixed, my lord.
16.
Lord,
Let it be on
I'm obliged, my lord.
16.
my lord, they need to show only one notification, my lord, then I'll be out of court. That it has been constituted on a section.
I have
That, my lord, they
I have
not been
submitted,
able to-
my lord. I have submitted that I have received the instructions. We are going to file the affidavit. We'll file it.
My lord, that notification has to be
Definitely.
shown, my lord, I'll be thrown out of this court.
Definitely we'll file the affidavit.
They cannot show that notification. That's why, my lord, deliberating the matter.
Look, from 2017 they are sitting, they are also sitting over
Point
the
of law
matter.
can be raised. at
Now,
any point of
that's
time.
true, but the urgency shown,
If the
urgency
trial
shown.
was before a court not constituted as per the provision of the Act, that is your first ground.
On the point of jurisdiction.
What,
That's true.
what,
That's true.
what more do you require?
That's
the first ground of the
Earlier also they have filed a transfer petition.
No,
before
don't
Honorable Court.
earlier things. You know, we went to Supreme Court, my lord. My petition was rejected. That, my lord, they want to prejudice by saying all those, my lord. I am on the back
No,
of
not
this case.
prejudice. They have totally
No, transfer petition was once
the
rejected,
question
my
of
lord.
prejudice.
Once
All right.
transfer petition, then maybe as a defend ground, maybe.
Anyway, my lord, 16th year, 16th year was decided. Published.
Delay of 2 days, my lord. That is case matter notice me. Or matter to
Heard and counsel for the applicant. This is an application praying for condonation of delay of 2 days in filing the related appeal. This is what? First appeal. Second appeal.
Second.
Against the judgment and decree dated so and so, passed in so and so. We'll have to issue notice. Anyone for the respondent?
No, my lord.
Issue notice to the
I may be
respondent.
allowed to take the appeal also.
Returnable on 15th. Trustee is also permitted. Steps on the respondents within 1 week from today by usual course, registered post as well as trustee.
Highly obliged, highly obliged.
Placed on 15th. Yes.
Lordship, I have marked the 164, Lordship.
I have one more submission.
164 is the Lordship of witnesses, Lordship. So up to date CD may be called for, Lordship. Because Lordship,
With CD.
it is investigation is going on, Lordship. They have received the phone call, Lordship. They have received the phone call without knowing the number. How can a person call them, Lordship?
No, my lord, thing is that I have the certificate.
What is the relation,
My
Lordship?
lord,
That
kindly
is
say
the
one more
reflected.
thing, my lord.
How is it that 164 are not available with you?
164 are there, Lordship.
Ah.
Witnesses are there, but not of the accused.
Then?
Only of the witnesses, Lordship.
No, accused are not examined, my lord, in 164.
Lordship,
My
the
lord,
phone number, Lordship, they have used, Lordship. How come they know that the phone numbers of this person, Lordship?
My lord,
There-
Use the phone number.
it accused, Lordship, the terrorist group, Lordship,
not a terrorist group, my lord, nothing was there, my lord, page
because
26.
they have rang up for help of taking the route, Lordship, without knowing, Lordship. That is not in the here, Lordship. So up to date case diary will be required,
Lord,
Lordship.
I have a submission.
But he's been in custody for how many days?
70 days,
my lord.
Lordship.
71 days.
Lordship, it is 90 days, Lordship.
Thing is this, my lord,
An investigation is going on, Lordship.
the suspected number 161 statement says belong to one lady.
Right. When do you want up to date CD?
Not the reopening, Lordship.
15,
16, Lordship.
16.
16.
You wait until 16. Heard Learned Counsel for the party. Learned APP submits that up to date CD is required to she gives leave to send the CD back and call for an up-to-date CD. Considering the period undergone by the writ petitioner, lays the matter again on 16th, on which date the petitioner, on which date, and the learned APP will place the updated CD as called for. Call for CD.
Yes, my lord. Because
Hoega.
Lordship.
16, my lord.
Hoega, when?
Lordship. 16, no, no, 17, no. 17, Lordship.
17. It's on 17. Hard. 424. 17 July. Yes.
My pleasure, Lordship. Here is an
Where's the FIR?
page number 12.
12.
So in the FIR, what has transpired is that the informant, he happens to be the ASI of Machkwa outpost under the Dhemaji police station. So what he has happened is that he has lost this FIR on the basis that of seizing of a vehicle having registration number AS03CC5984 of illicit Indian with foreign liquor from the vehicle. Now this vehicle belongs to the accused petitioner. How he is accused now? Because in the FIR, police have made him and the driver, the owner of the vehicle and the driver as the accused in the FIR when it is registered. So basic on the fact that he has been apprehended to be one of the accused, and now he is apprehending that he may be implicated because of the fact that he is the owner of the vehicle, the petitioner in this instant case. Lordship, the owner, he has given this vehicle to the driver to ply for carrying goods in the for as a vehicle to ply as a goods carrier. Now what has happened is that based on this FIR, police are looking for him. He is a head teacher of a lower primary school at Jorhat, at Moriani. That is page number 19, Annexure D. That is his ID card. So being a head teacher, he is now being called often by the police. Police is looking for him. So in the meantime, Lordship, it is prayed that
he must realize that he should focus on being a teacher, not carrying on business.
Absolutely no. He has given this vehicle to the driver to ply goods as a goods carrier.
But
So he's not
vicarious-
at all involved. He's not.
vicarious
Lordship, that
liability-
CDB there, Lordship.
Yes,
and
yes.
We don't have the file to, Lordship.
Huh?
We don't have the petition copy also, Lordship, as it is unlisted, Lordship.
Where is the file?
Lordship, let
it
the
has
CD be
been-
there, Lordship. Let the case diary be there, Lordship.
Yes, in the interim I may be protected.
No, Lordship,
Okay.
after receiving of the CD, Lordship.
My lord, I am a head teacher. So if there is anything that goes against
From
me,
Dhemaji, when can you get it?
Lordship on 19, Lordship,
19.
19.
All right.
Then I will be protected, my lord.
Petitioners when
because now it is a vacation
is apprehended
going on.
arrest in connection with an FIR dated so and so. FIR dated
3/6/2024.
5/6.
3/6. That date is 3/6 and it has been seen by the judicial magistrate.
3/6/2024,
Adita.
lodged by the informant who is the ASI of Maskwa OP
Under
under the Dhemaji police station. The allegation made in the FIR is that a vehicle bearing number AS03CC5984 was seized during Naka checking
1 to B. 1 to B.
on 3/6/2024 at 11 a.m. 12:30 p.m. And from the said vehicle, illicit IMFL. Number of illicit IMFL was recovered. Where is the driver? Is taken into custody.
He's as of now, police is also looking for him.
832024.
And there was one more person as per the FIR. I was not there. So that person's
The
name is also
petitioner
not there.
claims to be the owner of the said vehicle. He is also a teacher, head teacher employed in
218 LP Sonwal School, Sonwal LP School. 218 number, Sonwal LP School.
218 number Sunwal LP School in the district of Dhemaji.
No, at Morian. At Jorhat. The school is at Morian.
At Moriani in the district of Jorhat.
Cases of Dhemaji.
Oh, yes, of Dhemaji.
Learned counsel for the. Why don't you share a copy of the?
Yes, I have already.
No, Lordship, I am.
Oh, no, yes, already received.
The said FIR was received and registered as Dhemaji PS case number 83 of 2024 under section 379 IPC read with section 53A, 53(1)A of the Assam Excise Act. Stop. Learned counsel for the petitioner submits that he is indeed the owner of the vehicle. He is employed as the head teacher, but he is not involved in the activities alleged in the FIR. Stop. The vehicle was run by the driver and is the driver alone who is responsible for carrying goods, and if any illegal goods are carried in the vehicle, the petitioner is unaware about the same, and therefore he prays before this court grant interim protection during the investigation carried on by the police. So, let's see the call for. Is there an MBI report required for the vehicle?
Lordship, they will give.
Vehicle is seized now. It is still there. With
CDB call for matter be fixed on which date?
19, Lordship.
19 July.
19 July.
19 July.
In time, maybe.
In the meantime, if the
Till
petitioner is
19.
arrested, he shall be released on furnishing a bail bond of rupees 20,000 with one local security of like amount, subject to the following conditions. Where are you posted? Where are you residing?
I'm at Moriani only now. I am a head teacher there. So I'm working there and I'm
But
residing.
you'll have to appear before Dhemaji.
Yes, I will have to go.
Lordship, if interim is granted, Lordship, then the latest CDB on 24th of July, Lordship.
24th of July. 24th of July, petitioner will appear before the IO within 10 days from today, he will not move out of the jurisdiction of the police station without written permission of the IO. He shall not intimidate or attempt to influence any person connected with the case. And if any of these conditions are violated, the investigating authority will be at liberty to pray for cancellation of the interim bail granted.
My objection may be also recorded.
The learned APP, prior to that, learned APP objected to the grant of bail, submitting that the prayer for interim should be considered only upon perusal of the CD. Having heard, let CD be called for. However, considering the submissions of the council, in the meantime, we shall. Yes.
Obliged.
Yes.
Please, your lordship, I have been informed that all council on behalf of Arunachal Pradesh is lordship out of station. Lordship.
Is?
Out of station, lordship.
Then?
And lordship, I have informed to the court, lordship, I am appearing on behalf of BD Goswami, lordship.
Then what
So
can be
lordship
done?
may fix it on reopening day, lordship.
What is this matter?
My lord, here my petitioner was declared as L1, my lord. Declaration of L1, my lord. Respondent number 7 issued a letter to respondent number 4 in respect of an other NIT, saying that NIT should not be proceeded during the model code of conduct, my lord. Pursuant to that order was that letter was misread by the respondent number 4, and he cancelled all the 7 NITs, my lord.
He cancelled?
He cancelled 7 NITs, my lord, including the petitioner's NIT, where petitioner was declared as L1, my lord.
Then
That order I am challenging, my lord. And my lord, there were total 7 NITs were cancelled, my lord. One of the coordinate bench passed one order, my lord, in respect of one of the NITs where, my lord, the court has directed not there should not issue fresh NIT in respect of subject matter, my lord.
Where is that order?
Lordship will find it page 76 is the order, my lord. Protecting part of Lordship will find it page 80, paragraph 9, my lord.
Okay, heard. Mr. A.K. Gupta, learned counsel for the petitioner. Mr.
J.M. Gogoi.
J.M.
Gogoi.
Gogoi, learned counsel who appears on behalf of Mr. B.D. Goswami, learned additional AG, appearing with the state of Arunachal Pradesh. Stop at the outset. Mr. Gogoi submits that he's not a government advocate representing the state, but he has entered appearance as a proxy counsel on behalf of additional AG for the state of Arunachal Pradesh. And none of the government advocates representing the state of Arunachal Pradesh are presently available in the principal seat because of the ensuing vacation. So, where Mr. Gupta submits that the present petitioner is aggrieved by which order?
Lord, page 26, my lord.
26.
My lord.
Is aggrieved by the order dated
22/5/24.
22/5/2024, whereby the NIT in which the petitioner submitted his bid and where he was declared as the L1 bidder stood cancelled. In view of certain complaints received from public, youths, and panchayat leaders. As well as by following the Model Code of Conduct rule by the ECI letter number 437/6/2004 dated 5th of March 2009. Stop. Learned counsel for the petitioner submits that the contract was for
Construction of, my lord.
where is the NIT?
Stadium, my lord.
Lordship will find NIT at page 20, my lord.
The NIT was issued for construction of auditorium for Government Higher Secondary School in Koloriang and Government Higher Secondary School New Koloriang in the Kurungkume district. Headquarters at Koloriang, page number 20. Stop. In terms of the NIT, on the bid submitted by the petitioner, he was declared as the L1. Where is there any order?
Yes, my page 24 is there, my.
He was declared as an L1 bidder as per the bid evaluation summary enclosed to the writ petition at page 24. Stop. Subsequently, by the impugned order, the tender was cancelled. Stop. Learned counsel for the petitioner submits that the tender was not issued in violation of the Model Code of Conduct, but the same was cancelled only on certain objections raised by certain vested parties. Stop. Being aggrieved, he is before this court. He submits that this order at page number 79,
76, yes, my lord.
78
My lord.
is pertaining to similar.
Similar, my lordship will find it at para 9 of the order, and lordship page 7, page lordship will find it page 26, my lordship. The NIT is mentioned there, my lord.
Same NIT.
But different NIT, my lord. By this order, my lord, total 7 NITs were cancelled, my lord, including petitioners, my lord.
Page number 26.
26, my lord. And para 29 can be captured.
Page 26 reflects how many?
7, my lord. Lordship, the
Learned
NIT
counsel for the petitioner submits that by the impugned order dated 22/5/2024, in all total 7 NITs were cancelled. The persons aggrieved in respect of cancellation of other NITs by the said order issued by the executive engineer Sangram Division PWD had approached this court by filing several writ petitions, and in those writ petitions, while issuing notice, the court had directed that fresh NIT in respect of the work concerned should not be issued without leave of court. Stop. Learned counsel has referred to one such order available at Annexure 11 to the writ petition. Stop. Having heard learned counsel for the parties, issue notice returnable 4 weeks. Uh, Meanwhile, if the respondents will not proceed for fresh publication of the NIT in respect of not proceed for fresh publication of the works which were earlier invited and subsequently cancelled by NIT number para 3.
My lord, yes,
Page number 6.
My lord, it is 6, NIT number 6, my lord. Serial number 1/3 line, my lord.
Page number
26, my lord.
40.
26, my lord.
26.
It is in the 3rd line, my lord. It is in the
NIT
3rd line.
Yes, number.
My lord, SGMD/NIT/KLG/2023-24/03.
03. Page number 20. Works which are earlier invited through NIT number so and so shall not be invited without further leave of the court. Matter be listed again on 5th of August. Huh? Matter be listed since this matter has been filed, it's permission from the Honorable Chief Justice of the administrative side in the principal seat as the appropriate bench, if the Itanagar bench is not available, the matters be transferred to the Itanagar bench to be taken up immediately after the reopening of the vacation. matter be listed in it. Ranagar Bank on 17 July.
My lord. It is also similar, my lord. Only
Similar.
nature of work is different and my NIT number is different, my lord.
Where is the cancellation order?
Lord, page, sorry, my lord.
28.
My lord. 28, my lord.
Where is the NIT?
My lord, in the second line, my lord.
Huh.
No, in the second line, my lord, may I read, my lord? SGMD NIT KLG oblique 2023-24 oblique 02.
02.
02, my lord.
All right. And where is the work?
My lord, NIT, lord, it is page 21, my lord.
21. Nature of the work is that page 21. Multi-purpose stadium of so. He was adjust as in person to the bid submitted. He was the petitioner was found to be the L1 bidder. Where is that finding?
Page 26, my lord.
26. The L1 bidder. You are AP.
AP Enterprise, my
L1 bidder. And cancel by page number 28.